With you. Yes.
The Lordship's indulgence, I'd like to mention a matter which was posted in the court of Honorable Justice Surana. His Lordship is not sitting. This is item 18, my lord. It's a motion matter.
I don't have his list. Where is this?
Thirty. The Lordship, my lord, can take up.
Wait. Let me get it technologically more steady. 25th, no? That is Surana?
My lord.
Yes. Tell me.
Can it be taken, my lord? Some urgency.
Item number?
818.
What is the matter about?
My lord, the president and vice president of the Cooperative Society has been removed, my lord, divorced the legal position. My lord, under section 36(4), there has to be 3/4 member in order to removal of the director. Now, without doing that, my lord, the minority directors have removed. And as a result, my lord, the society is in a chaotic position. My lord, we are not in a position to take any decision. No work can be done.
Item number 18.
18.
It's in the supplementary list.
Supplement.
Supplementary list is where? Not there. Now supplementary list just let us hear the other people. I'll take yes, item number supplementary. Oh yes, it's a motion matter.
Motion.
Okay, we'll take it.
Oblige.
Not similar. Roughly 19-year-old motion. Justice Purana's quoted.
Okay.
Demolition matter is 19.
Item number 21, Lordship.
We'll take the motions. Any other motions are there?
21, Lord.
18, 19, 20, and 21.
21
take
is
it.
mine.
Okay, we'll take. And 20 also we'll take it.
I have another matter, my lord. Item number 14. Court number 7.
Court number 7.
7.
Item number
At least
14.
My prayer is that let the matter be on Thursday, next Thursday, on 3rd of August. I'm led by Mr. K.N. Chaudhary. He has a talk with.
Don't listen.
No.
Wait. Let me get the other list.
Tuesday, Tuesday,
Yes, any my bench, any matter to be adjourned? Any matter? Yes, tell me.
May please, Your Lordship. I beg to mention item 21 for adjournment.
21.
We've taken consent from the other side. There is an interim order, and the interim order may be.
You want an adjournment? Very well. No problem. No interim order.
14, my lord.
Mr. Sahib, just wait. Let me get the
Yes,
list.
sure.
Yes. Where's the other side? Yes, anybody wants to do item number 1 and 2 in court number 7? Yes, item number 14, Mr. Sahiwala, yes, tell me. What is it?
This is urgent matter, my lord.
Okay, we'll take it.
I'm praying for on 3rd, Lordship.
No.
So I'm filing my.
Is there an interim order?
Interim order, my lord.
We vacate the interim order. We can have it next month also.
I'm filing the objection today, Lordship.
You file it, we'll take it up at 2. Ask Mr. Chaudhary or you argue the matter. It's the interim order and there is this matter in, what is this? Tender?
Tender matter, my lord.
So one day accommodation I'm asking Lordship.
No. If he wants to do it, he has to. We otherwise vacate the interim order.
So otherwise, also on Thursday, Lordship. Because
No
He
Thursday.
doesn't have any obligation for Thursday. I'm in a difficult today, Lordship. Kindly, Lordship.
No.
Today is Tuesday, next Thursday, Lordship.
14 will take it. Yes, anybody wants to do the motion items of court number 7? Yes, Mr. Ahmed.
If you to mention item which is not the unlisted motion, the urgency is that tender will be open today.
Okay, we'll take it up at 2.
May I please, your lordship? May I please, your lordship? My lord, I am paying for listing of this matter, my lord. Matter pertaining to bench 4, my lord. Because it is a eviction matter, it is a business are residing in the disputed area.
Motion?
Along with the border of
The motion
motion, my lord.
today,
Tomorrow, my lord.
tomorrow, okay.
Well, please, your lordship. My lord, I'd like to this motion case as unlisted matter because there is a eviction drive, and though it is my patta land, still they are trying to demolish my area because they have put the line in such a manner it crossed my property, my lord. I have got the patta, everything is there.
2 o'clock.
My lord, I'm praying for listing a matter, my lord, on 28 minutes. Friday.
For?
Friday, my lord, for admission.
Why?
My lord, the allotment of PMA by house, my lord.
Huh?
For the petition is for the, my lord, for allotment of PMAY house, my lord.
You can mention it when the regular bench sits.
My lord, regular is not
You
here.
mention it tomorrow before the regular
Okay.
bench.
My lord, I beg to mention for listing a contempt for tomorrow. For
Why?
the matter pertains to an outstation will come.
Okay. Take it up.
May I please, your lord. My lord, I am saying for the listing a case on tomorrow. There is some urgency that contract matter, my lord. It is the tender will be issued on day after tomorrow. So
Motion.
motion. I have already filed. I am permitted to list on tomorrow.
Okay.
May I please, your lordship?
My lord, I beg to mention a petition for listing for withdrawal on tomorrow.
May I please, your lordship? Lordship, I beg to mention a matter for listing, lordship. The matter pertains to bench 4, lordship. So kindly the matter may be listed tomorrow, lordship. It is a bit urgent because we have challenged the work order and the work order is effective from August 1st. So kindly, lordship, it may be listed tomorrow.
We'll have it on the 28
20?
Eight.
28.
to 8.
26? 26?
26 is tomorrow. We'll have it on 28.
28.
Also, I beg to mention for listing for pending petition for admission.
Mention it before the regular bench. Twenty 2021 to okay. Highlight it.
Court number 17, item number 1.
Yes, who is appearing for whom? You are appearing?
Yes, Manan appears for the petition.
Where is he? Chalo, we'll take it after some time. If he doesn't appear, we'll dismiss for default.
Item number 2.
Yes,
During the petitioner, he was operating a CIC community information center is centers were opened as per the scheme of the central government, Your Lord.
But the central government has closed it. What to do? And why have you made the central government a party?
Yes, my lord.
Then
But my lord, our prayer is
you have not made the central government a party. The central government has done all the mischief.
my lord, there was a stay order in a different case by this honorable court with respect to the integration of the CICs with the common service.
What
center.
happened to that matter?
That was disposed of, but initially there was a stay.
What
order
happened to that matter?
That was dismissed actually in
No,
2013, my lord. So,
Nothing remains.
but after that, my lord,
You see, the problem is there is a specific stand being taken by the respondent state, stating entirely that, look here, this CIS business out there was conjoined with the other one, CSC.
Yes.
There was a status quo, but they had the government of India has not extended it. How do you get the money?
my lord, the money, when initially the minutes and also the CIC scheme.
Tell me whether the CIS scheme is still running.
No, my lord. But my lord, the money that we had earned through the CIC, that only our prayer is limited to that money, because we had earned a profit from that, our money be paid, my lord. And that provision is there initially in the minutes also in the CIC scheme also, my lord.
Now, is it your case that you did not get for that period when there was no stay?
I got till, my lord,
Or
December
did
2008.
it on account of the amalgamation of the CIS with the CSC? Thereupon, you have not got. Which one?
No, my lord, when there was a stay, it was in 2000.
I'm not concerned with the stay. The stay automatically goes. I'm in view of the dismissal. Because we are now adjudicating it. Is it your case that pursuant to or prior to the amalgamation of the CIS with the CSC,
My lord.
you have not been paid? No,
Yes,
that's not your
because
case.
The dismissal happened in 2013, my lord.
I'm not concerned with that, Mr. Counsel. I'm not concerned with those. I'm only asking you a specific question. Is it your case that prior to the amalgamation of the CIS with the CSC, you were not paid?
On paper, my lord, integration happened earlier, but actually when there was a status quo,
But status quo has become vacated because as of now we have to take into account that the writ petition was dismissed. That means that particular decision which was taken was right. So as of now, we can't revert the matter back to that particular position.
I operated till 2012, my lord, and until 2010 April, I had shown that there was profit amounting to 210,000. So
Mr. Counsel, I am specifically asking you a specific question. The question is this. Is it your case that prior to the amalgamation, you did not get the amount?
No, prior to that I got.
What is the date of dismissal of the writ petition?
My lord, that is 3/10/2013.
The petitioner herein being aggrieved by the action of the respondent authorities in not releasing the salary remuneration to the petitioner from the savings of the center. Has approached this court by filing the instant writ petition. The facts of the instant case is that in the year 2002, the government of India had introduced the project in the name of Community Information Center with the aim and objective to accelerate socio-economic development in the northeastern region, including Sikkim. To the same effect, the government of India had also entered into a memorandum of understanding with the concerned states through their respective chief secretaries it has been further mentioned that in terms with the Memorandum of Understanding, National Informatics Center was the implementing agency appointed for the purpose by the Government of India. The National Informatics Center was entrusted to maintain intimate liaison with the state government authorities and also to supervise the functioning of these centers. It was further stated that as per the Memorandum of Understanding executed between the central and the state government's role inter alia was to deploy suitable persons in these centers. In terms with clause 5.1.8.3, the control and management of the centers was proposed to be transferred to the central government for the period of 5 years from the date of commissioning of these centers. It was further mentioned in the petition that the state government was also required, as per the memorandum, to engage services of 2 operators for each center on contractual basis for a period not exceeding 5 years. And the remuneration of these 2 operators for a period of 5 years started from 2002 was to be borne by the central government. In the backdrop of the above, it is further stated that the petitioner was selected as one of the operators of the Community Information Center established in Nalbari. It has been further mentioned that while the petitioner continued to operate as continued to function as the operator of the Community Information Center, a decision was taken by the Government of India in the year 2007 to merge these community information centers with the common service centers proposed to be set up. The central government also took the decision that a remuneration would be paid to the operators of these community information centers, subject to the condition that these community information centers are merged with the common service centers. This decision of the central government was challenged in a writ petition filed before this court, being WPC number 2536/2008. By an interim order dated 26/2008, the parties, this court directed by an interim order dated 26/2008, this court in WPC number 2536/2008 directed the parties to maintain status quo. It is the case of the petitioner that pursuant to the passing of the said order, pursuant to the decision of merger of the Community Information Center with the Common Services Center, the respondent authorities stopped the payment of his salary to the petitioner, and as such, being agreed, has approached this court by filing the instant writ petition. It is relevant to take note of that in the instant writ petition, the Union of India is not a party. It further appears from the records that on 29/9/2011, notice was issued by this court. The record further shows that the respondent number 1, that is the Commissioner and Secretary to the Government of Assam Information and Technology Department, had filed a affidavit in opposition through its Deputy Secretary. In the said affidavit in opposition, it was mentioned that as per letter number IT.89/2006/PT/Roman 2 capital /15 dated 2/5/2008, issued by the Commissioner and Secretary Information Technology Department, the integration of the Community Information Center with the Community Service Center was envisaged, and the existing 2 CIC operators of each would be preferred in the service of the Service Center Agency (SCA) Village Level Entrepreneur or Village Level Entrepreneur Operator on terms and conditions not inferior to the current ones and on mutually agreed conditions. It was further mentioned that after the expiry of the period of the CIC scheme, the central government took the decision to merge the CIC with the CSC, and the CIC operators were not left to fend for themselves. Further to that, it was also stated that in view of the status quo order, the merger of the CIC with the CSC did not take place. It was also mentioned that the state government, State of Assam, is in no way responsible for payment of the honorarium to the CIC operator after the closure of the CIC scheme by the Government of India. In paragraph number 6 of the said affidavit, it was also mentioned that after the expiry of the term of the CIC operator, no specific order was issued regarding continuation of the service and extension of the job agreement, etc. It further reveals from the record that the General Manager in charge District Industries and Commerce Center had also filed an affidavit on behalf of the respondent number 4. In the said affidavit, it was mentioned that the central government took a decision to merge the CIC with the CSC. The General Manager DICC, Nalbari, was no way involved in the salary matter from March 2008. It further reveals from the record that the General Manager District Industry Center, Nalbari, had also filed an additional affidavit on 31/1/2018. It was mentioned in the said affidavit that the petitioner was appointed as the CIC operator and joined as a CIC at the CIC Community Information Center of Coop Nalbari Development Block on 6/6/2002. And since then, the petitioner was regularly drawing remuneration on contractual basis at 5,500 rupees per month up to 31/3/2008 from the District Industries and Commerce Center, Nalbari. Thereafter, as the salary for the CIC operator was drawn by the Managing Director Bamuni, I'm from Bamuni Medium, and as such, after 31/3/2008, regarding salary matters of CIC operator, the managing director Mtron was the competent authority to reply for such drawal of fixed remuneration of the CIC operator. To the said additional affidavit, the agreement entered into between the petitioner and the chairman, district level committee of community information center was enclosed. In the said agreement, amongst various clauses, clause I stipulated that the first party did not undertake to provide alternative opportunities to any of the CIC operators, nor pay any compensation in case of closure of the centers due to any reason, nor undertake to provide any relief compensation for any injury that might occur during the work. I've heard the learned counsel for the petitioner. Mr. Your name?
Yes, my lord.
As they, appearing on behalf of the petitioner, have submitted fairly that the writ petition, being WPC number 2536/2008, by which the decision to merge the CIC with the CSC was challenged, was dismissed by this court by an order dated
3/10/2013.
3/10/2013. It further reveals from the records that as per the agreement entered into, the reveals from the record that the petitioner was contractually appointed as a CIC operator on 4/6/2002. it is an admitted fact that the amount to be paid that the remuneration which was to be paid to the petition was to be disbursed by the central government authority. The central government had taken a decision to merge the CIC with the CSC. And though the said decision, though a status quo order was passed by this court in WPC number 2536/2008, but the said petition was dismissed by this court by the order dated so and so 13. Therefore, the decision which was taken by the Union of India to merge the CIC with the CSC have been approved. No, was not interfered with and have attained finality. It was the further stand, the central government further mandated in the decision that they would continue to pay the remuneration subject to the merger of the CIC with the CSC. These decisions the above would therefore show that the central government was a necessary party to the instant proceedings, as they were the authority at whose behest the state authority had entered into the agreement with the petitioner. It further reveals from the contractual agreement entered into between the petitioner and the respondent, as well as with the chairman of the
District level committee on CI.
district level committee of Community Information Center. That the latter shall not be in any manner responsible for providing alternative opportunities to the CIC operator, nor pay any compensation in case of closure of the centers due to any reasons. Under such circumstances, in view of the express condition in the agreement, which have also not been put to challenge in the present petition, the relief which has been sought for in the instant petition cannot be granted. Accordingly, the petition is devoid of any merits for which the same stands dismissed. Aile.
Court number 7, item number 18 for motion.
Wait, Sidra.
Tell me,
The petition number 1 and 2.
where is the corporation department?
My lord,
They have done the,
Mr. Talukdar, I have requested him to be here.
okay. Just tell me,
My lord,
hey, cooperative society.
petitioner number 1 and 2.
Hmm.
Are the president and vice president of the Dibru Dangri River Part 1, Minchava Samiti, my lord. And they were legally elected by AGM dated 10/5/2022.
Petitioner number 1 and 2 are the president and vice
Vice
president
president,
of the board of directors.
my lord.
Okay, then,
And petition number 3, the secretary appointed by the board of directors.
okay.
Now, petition number 1 and 2, along with some other board of directors, my lord, they took a decision to remove the respondent number 6, who was asked by the secretary because of the financial irregularity.
He was the secretary.
He was the secretary, respondent number 6. And because of various financial irregularities, he was removed. Now, that was approved by the assistant register, who is the respondent number 5. Now, at the instance of this, my lord, the ousted secretary, my lord, the respondent number 4, who is a
Yes, Mr. Talukdar, your matter.
who is a joint register, my lord, he has interfered with the decision dated 16/6/2023, by which, my lord, the respondent number 6, the secretary was ousted. And my lord, he said that he should be temporarily accommodated for 10 days, and the inquiry should be conducted so for meeting dated 16/6/2023. Now, in the meantime, my lord, what secretary did, Aspel secretary, he held a meeting.
The
saying
respondent number 6.
that- Respondent number 6. He held a meeting saying that the president, that is the petition number 1 and 2, there is certain allegation against them. And he held a meeting saying that they should be removed. And my lord, they were removed by holding that meeting. And you also will find under section 36(4), if you want to remove them, you will have to give them a notice. They did not do anything. It was done without hearing them. Secondly, very pertinent thing, there is a violation of statutory act. What they did, if you want to remove, you must, under section 36(4), 3/4 of the board of directors will have to be present. So in this case, what happened, out of 14 board of directors, 8 directors were there. And if it is to be 3/4, there ought to have been 10 number of directors. This is the main violation, my lord. And the secretary has become functus officio since he was removed, despite the fact the respondent number 4 in the meantime interfered. In the sense, he could have filed an appeal, he did not file it. And even the 8 members who participated, my lord, they were the signatories of earlier meeting dated 16/6/2023, where they have the party to removal of the respondent number 6. And they became a party here, the proceeding dated 5/7/2023. Now, these are the, my lord, the
So
violations.
you are mostly concerned, there are two things. One is the thing that the quorum was not there.
My-
And there was no notice pre-issued.
Exactly.
These are the two primary.
My lord, these are the two.
Yes, Mr. Talukdar.
Yes, well, in fact, in this case, this is a lease, well, between the secretary and some of the board members. Now, what your lordship, whether your lordship passes interim order or whatsoever, I'm not on that. But I want to apprise your lordship regarding the position of law in this regard. Now, first and foremost, my lord, the dispute between the secretary and the board, my lord, can be resolved only by the register. If your lordship comes to 49(2)L, this is the power conferred on the register. 49(2)L. In case of dispute between the chief executive, my lord, he is also known as the register, and the board in the matter, the decision of the register shall be binding on the board. Now, what I find that certain orders has been passed either by the zonal register or the ARCS. Now, the power under 49(2)L, my lord, is not conferred or delegated rather to any other authorities, my lord. So it is only the register, my lord, who can adjudicate the matter. In that view of the matter, my lord, certain orders my lord, very fairly submitting, my lord, of the, from page 73 onwards, either of the assistant register or the general joint register, my lord.
Of interfering with
My lord, my
the
lord, yes.
respondent number 6. thing.
Exactly, my lord. That cannot stand because this, my lord, has to be clarified, number one. So therefore, whatever resolution, rightly or wrongly, my lord, has been adopted against my lord.
So these
respondent-
aspects ought to have been done by the register.
Exactly, my lord. And there is a notification of the government of Assam.
But what do you say about the other context? We'll go.
Yes,
This is on the when the other side respond number
Correctly.
6 appears.
Correct.
Now,
Now,
prima facie, as of now,
yes, yes,
Mr. Doctor has submitted
my lord.
two submissions which appear to be reasonable also. It mandates that for the purpose of ousting the president or the vice president, you need a quorum
Correct.
of 3/4,
Correct.
which is not there.
Yes,
Secondly, you are to put these people to notice,
Exactly.
which have not been.
Yes.
So under such circumstances, this he is asking for challenge of which one? You are challenging which?
My lord, your lordship may see at page 80, my lord,
Challenging
80 and 81. 80A, my lord, at page 80A, my lord, your lordship kindly see. The order dated 5/7/2023.
now what is this 80A has to go?
80A is the order of interference of the order dated 16/6/2023,
It has been interfered with.
my lord. And the next at page 81, the proceeding.
my lord, if my
It
submission
is only temporarily vacated.
My lord, then the further inquiry to be conducted.
No, it's okay. Well, but
And then,
where you are challenging which one?
At page 81, your lordship kindly see.
81. This is the proceeding
My lord, this is the proceeding.
by which you have been ousted.
Exact,
Now you are asking for a stay of this.
my lord.
And what else?
My lord, 80A and 81 is two order and
What is
proceeding.
this 80A?
80A is,
80A, if I stayed
my lord.
without hearing the respondent number 6, wouldn't it affect him? Oh, you are there?
I am
Fantastic. Good reasons for it.
Is there,
Staying.
I have filed in caveat.
Oh, very good. You are respondent number 6. Now tell me, what do you have to say as regards this?
That lordship,
let me.
How did the assistant register act on this?
lordship, I am the secretary of the cooperative of the.
Understood, but you have been removed.
Section 36, lordship.
You were removed on 16/6.
6, lordship.
How did the assistant register interfere?
I filed a representation before the assistant
No,
registration regarding
but
that.
can this dispute between the chief executive with the board be decided by the chief? You are there, we dispose of the matter then. Why should we go into the question of stay?
Before that lordship present in this case, lordship, I am clarifying that before this lordship, there is an alternative remedy regarding this present case before your lordship. Section 36(4)(5), lordship.
You have filed an appeal.
Yes, yes.
What has
lordship,
happened
we
to the
have
appeal?
filed an appeal. They did not pass any order.
Annexure
Instead, my
89, lordship.
Annexure 89, this is the. Let me say, my lord, instead, my lord, in interfering with the order, my lord, they have issued notice and it is fixed on 28/7. So therefore, my lord, the
20?
offer 28/7. Annexure 107, lordship, this is the notice, lord. Now, so far alternative remedy, my lord, your lordship is well aware, if there is a statutory violation, in that case, my lord, the lordship can interfere under 226. There are so many decisions.
So what is the urgency that the matter needs to be taken up today?
Now, my lord, the lordship can list it without president, without vice president, without any.
That can be very well taken on 28/7. By the before whom have you filed the appeal?
My lord, before the register.
The register you have filed, the
Sir,
register will
kindly-
take a decision on 28.
Now, when there is an accuracy illegal things, we have.
Understood. You will be obviously at liberty to come back here.
Section 36(5), lordship.
No,
If there
when the
that,
appeal is
they will-
there, notice has been issued. Why doesn't the register take up a decision? Mr. S.K. Talukdar, you have a control over the register? No, I'm saying, do you appear for the register?
Before this honorable court, yes.
Can the register not be asked to dispose of the appeal as early as possible?
Yes.
I think that is the best option. As the appeal is pending and the petitioner is aggrieved, then thereafter it is always here, we are in open arms. to accept his petition, then
My lord, there is one notification also,
Only thing-
clarify that aspect. That 49(2)(l) has not been conferred to any authority. My lord, these orders are being passed by subordinate officers. Because it is only the register. Here also I have seen, my lord, certain orders has been passed. That cannot possibly clarify that. Otherwise matters are coming by this type of.
the problem arises now is this. The appeal is fixed on 28/7. How can this court decide this?
No, appeal is already, my lord, before the register, it is not before any other authority.
But if can I prejudge it now? Wouldn't I be, if I say anything, wouldn't that
Ah,
amount of
yes,
prejudging it?
yes, correct.
We'll direct the appeal register to decide this as early as possible within 10 days from today.
My lord.
And after that, you are at liberty to come. We will take you.
The only thing, my lord, the register,
No,
whether-
Mr. Dotto, if you have not filed the appeal and come before this court, I would have definitely set aside everything. But you have filed an appeal. The appeal is fixed on 28/7. It won't be proper on the part of this court.
Then exact 16, Lord, what they will do on that day, this or that reason, my lord, they might adjourn. So if you lord.
No, therefore, I am directing the appellate authority to dispose of the matter within 10 days.
10 days is not required because it is still on 28/7. The lordship may say that on that date it will be taken up and adjudicated.
Mr. Dotto, 10 days, I think, is a better option. Giving them on that day, it would be very difficult. Just for example, see the predicament of this court sometime. If the Supreme Court tomorrow says that you are to dispose of the matter on such and such day, I may have a lot of other works out there. How can I do it on that
Very,
day?
very.
I think giving them a leeway of 10 days, I think. If not, you
Only-
come before this court.
Only thing in the meantime, my lord, there may not be any cooperative action taken by the register or subordinate. Because one way, Mr. Talukdar is correct to say.
No, no,
these
Mr.
orders should be
No,
passed.
the thing is, something has been passed.
Yes.
Against that, you have already prepared an appeal.
Well.
The appeal will be taken, decided. You are at liberty thereafter to come before this court.
That's true.
I will record these, what you have submitted,
Well.
and say that let these matters be agitated before the,
All right. In the meantime, my lord, no action may be taken.
what action? The
No,
action,
there
what
is
is the has
Nothing
been
is,
taken? Yes, what do you have to say?
My lord, I am representing 9 and my lord. 7 and 9, my lord. My lord, my only prayer is that, my lord, since the appeal is pending and appeal is fixed on there,
Say something new.
my lord.
You have already taken the decision. Say something new.
So, my lord, nothing new, my lord. Actually,
Then
my prayer is that let
Take a
me.
seat. Okay. The instant repetition, I'm disposing it off.
Fine.
The instant repetition has been filed by the petitioners herein challenging the resolution who has filed the appeal.
We file that.
Why are you asking for setting aside and quashing the notice, impugn notice issued by for fixing the appeal for hearing on so and so?
That is, I'm not pressing that.
Huh?
I'm not pressing.
Obviously. Challenging the order dated 5/7/2023 issued by the in charge Zonal Joint Register of Cooperative Society Jorhat, as well as the resolution. What is this resolution? Nah?
Resolution.
resolution dated
5/7.
5/7/2023, taken in the purported meeting of the Dibru Dangoria River Part 1 Mean Samavai Samiti Limited. The record reveals, from the materials on record, it reveals that the petitioner herein, petitioner number 1 herein, is the president of the Cooperative Society in the name and style of Dibru Dangoria River Part 1 Mean Samavai Samiti, for short referred to as the Cooperative Society. The petitioner number 2 is the vice president of the Cooperative Society of the said corporate. Petitioner number 2 is the petitioner number 2 and 3 are the vice president as well as the secretary of the said Cooperative Society. On 16/6/2023, a meeting was held of the said Cooperative Society. Meeting was held of the board of directors, of the members of the board of directors of the said Cooperative Society, wherein taking into account the various allegations, or taking into account various illegalities being committed by the respondent number 6. The respondent number 6 was removed from the post of the secretary of the said Cooperative Society in exercise of the powers under section 38(2) of the Assam Cooperative Societies Act 2007. Immediately thereupon, on 26/2023, the Register of Cooperative Society was duly informed that the respondent number 3, petitioner number 3, was appointed as the secretary of the said Cooperative Society. It further reveals that on 27/6/2023, the assistant registrar of the Cooperative Society Tinsukia had issued a communication to the officer, to the assistant registrar (M) office of the assistant registrar of Cooperative Society Tinsukia, thereby asking the latter intimating the latter that some of the members of the said Cooperative Society had submitted complaint as regards the resolution number 1 of the meeting of the board of directors held on 16/6/2023, and thereupon directed that after making an inquiry in respect to the same, the latter was requested to submit a report within 7 days. pursuant to the said communication issued by the on the same date, another communication was issued by the Assistant Registrar of Cooperative Society, Tinsukia, wherein it has been mentioned, thereby intimating the petitioner number 1 that a departmental officer have been appointed to make an inquiry in as regards the allegations made pertaining to the meeting of the Board of Directors held on 16/6/2023 and the approval in respect to the resolution number 1 of the meeting of the Board of Directors dated 16/6/2023 is suspended for the time being till completion of the inquiry and till completion of the inquiry, the respondent number 6 be allowed to carry out the function of the secretary. It is further relevant to take note of that an FIR was filed by the petitioner number 1 before the officer in charge of Dhola Police Station relating to certain misappropriation of amounts being made by the respondent number 6. The said FIR was registered and numbered as PS case number Dhola PS case number 27/2023 under section 406/420 of the Indian Penal Code. Pusto. The said FIR was registered on 3/7/2023. Pusto. Immediately on the next date, on 4/7/2023, the Assistant Registrar of Cooperative Society Tinsukia withdrew the communication dated 27/6/2023, whereby the approval in respect of resolution number 1 of the meeting of the Board of Directors dated 16/6/2023 was suspended for the time being. The said communication as well as the respondent number 6 be allowed to carry on the function of the secretary till completion of the inquiry. On the very next date, on 5/7/2023, the in charge Zonal Joint Register of Cooperative Society vacated the communication vacated The communication bearing number DTC bracket P 45/74/PT.5/331 dated 4/7/2023 issued by the Assistant Register of Cooperative Society, Tinsukia, for 10 days. The in charge Zonal Joint Register of Cooperative Society further directed the Assistant Register of Cooperative Society to submit the evidence of the FIR, whether it is registered in the police station or not, within 3 days of the receipt of the letter for further action. The Assistant Register of Cooperative Society was further directed to submit an inquiry report of Sri Rana Bhattakur, Sub-Register of Cooperative Society, bracket Miss Tinsukia, for further necessary action from the end. This order, dated 5/7/2023, issued by the in charge Zonal Joint Register of Cooperative Society, Jorhat Zone, has been put assailed in the instant writ proceedings. On the very day, on the very day on which the in charge Zonal Joint Register of Cooperative Society, Jorhat Zone, had stayed the communication dated 4/7/2023 issued by the Assistant Register of Cooperative Society, Tinsukia, a meeting of the Board of Directors, a purported meeting of the Board of Directors was held in the said meeting so held, in the said purported meeting so held, it was resolved, amongst others, that the petitioner, as well as the petition number 1 and 2, it was resolved that the chairman of the meeting held on 5/7/2023 was authorized to take action against the petitioner number 1 and 2 by removing them from the society and confiscating their shareholding, and for indulging in the conspiracy for destroying the society. The petitioners herein, the petition number 1 and 2 herein, who were not put to notice in holding the meeting held on 5/7/2023, thereupon had preferred an appeal on 36 under 36(5) of the Assam Cooperative Societies Act 2007 before the Register of Cooperative Societies Assam, challenging the meeting of the Board of Directors dated 5/7/2023. Upon the said appeal, which was filed on 18/7/2023, I filed an appeal on 18/7 bill on here under section 36(5) of the Assam Cooperative Society. The Eastern Register of Cooperative Society Tinsukia, Cooperative Society bracket GEN, fixed the matter, fixed the appeal hearing on 28/7/2023. In the office of the Chamber of the Register of Cooperative Society. The petitioners herein being aggrieved and apprehending that serious mischief may be caused by the respondent number 6 and others, in pursuance to the board's meeting held on 5/7/2023, wherein a resolution was adopted to take stringent actions against the petitioner number 1 and 2, have approached this court by filing the instant writ petition. Mr. Talukdar, after seeing the facts, I think I stayed at board of meeting till the decision. This is not done. Because what they have done is this. Let the register decide it whenever it is. On the very day on which, on 4th, there was a stay. On 5th, it was removed. And on the 5th, on very day, this board of directors meeting. This can't happen like this. I can't, as he has approached the Register of Cooperative Society, I can't not touch on that because it won't be proper. But this needs to be stayed. Mr. S. Dutta, the learned counsel, senior counsel appearing on behalf of the petitioner submits that the Assam Cooperative Societies Act 2007 mandates a manner in which the meetings are to be called and the manner in which the president and the vice president of the cooperative society can be removed. Where is the notice meeting? Notice of the meeting?
So in fact, there is a special procedure prescribed under 43, my lord, 3.
43,
43(2), my lord.
43,
43(2). This is like, my lord, the Panchayat Act. The requisition is necessary.
President or the chairman in the event of his being meeting.
It's a special meeting.
So 15 days.
15 days.
How did they
In this
do?
case, it was done on the same day.
The learned senior counsel has drawn the attention to section 43 of the Assam Cooperative Societies Act 2007. As to how the board meetings are required to be called. Referring to section 43(2), it has been submitted that the president or the chairman, and in the event of his being physically incapable of acting, the vice president or the vice chairman may, whenever he thinks fit, call a special meeting of the board and shall be bound to do so within 15 days of the date of receipt of the written requisition. Signed by not less than 1/3 of the directors of the board, or from the register, or from the auditor. It has been further submitted that such requisition has to contain the reason as to why the meeting is felt necessary and the proposed agenda. In terms with section 43(3), if the president or the chairman, the vice president or the vice chairman, as the case may be, fails to hold the meeting of the board under subsection 1 or the special meeting of the board under subsection 2 within the period specified therein, he shall cease to be the president or the chairman, vice president or the vice chairman, as the case may be, on the date of expiry of the specified period. Mr. Talukdar, this is not the provision for that. For calling for a meeting, what is it? This is what will happen in terms of 15(1). The meeting, how it is to be called. But how do you say the meeting? What is the period for the meeting? There has to be some clear dates. Like in Panchayat Act, it says 15 clear dates. What is the year? Cooperative society, how do you call the meeting? I think we have to see, subject to the procedure to convene and conduct the meeting of the board shall be such as may be specified in the bylaws. You have the bylaws, Mr. Dutta? You have the bylaws?
Lord, subject to correction, I'm told that it's not there. The Talukdar can enlighten.
How can you be registered without the bylaws? Don't you think that this is a fit case for dismissing the president and the vice president for not knowing that there is a bylaw?
No, it is there.
Then where is it? Show me. The president and the vice president, they have contested, they don't know about the bylaws. You don't have a bylaws.
The bylaw is there.
Where is it? Where is the procedure for calling for the meetings?
They got to be, my lord. Otherwise, how the meeting will carry on? There must be bylaws. Without that, my lord, meeting cannot be carried on.
Then where is
There-
it?
There are certain
No,
periods
no,
which-
Mr. Dotto, kindly don't make that big submission. Kindly tell me where is the bylaws? Or show me that what is the meeting? When can a meeting be called? Or I can do one thing, I can dismiss the petition and hold it, you go there,
Just one.
and you don't have anything.
My lord, you'll have to take it tomorrow, my lord. I'll just try to.
Tomorrow, this court is not sitting up this matter.
At two.
That is better if you say so. Otherwise, this court is only for today.
I'm,
And after dictating so much, and now you say that tomorrow,
no.
so we should impose cost upon the council. Huh? 1,50,000, you are there? 25,000. To be paid to Mr. TJ Mohanto. 1,50,000 and 25,000. Do the work.
At two.
Find out.
Obliged.
Yes.
In fact, your lordship, the petition number has constructed his building after the accorded construction permit in 2011. Now, the respondent number 5 here in private respondent. He is my neighbor. He is my neighbor.
Driver.
Respondent number, yes, 5. He has raised some objection regarding alleging that I had made the construction illegal. In 2021. Boundary was demarcated. It was found by the Latmander report that the respondent number 5 has encroached 3 feet land on my southern boundary. Now, finally, he has filed a writ application before this honorable court. And ultimately, on 23/3/2023, the entire matter ended by a order of the Honorable Demolition Bench of this honorable court. May I kindly have a request this honorable court to have a look at page 35. Or she would find some facts therein leading to this.
Where?
35.
Who filed the requisition earlier?
Earlier, this respondent number 5, the private respondent, who is my neighbor,
What is his name?
is Yishu Kalanti.
Okay.
He is respondent number 6 in the division time, this readable.
Now, he filed the petition.
Yes.
Alleging,
Alleging the illegal construction by the writ petition of this.
then what happened?
Then initially the writ court has passed an order directing the authority concerned to make a field verification, and if any deviation is found, then take appropriate as per law.
On an authority, namely the.
Then a final demolition order was passed.
An action in accordance by noting the deviation found and recorded in the field verification. Step be taken expeditiously within a bound of 6 weeks from the complaint. Then what happened? You file a review.
Then we challenging the demolition order, then review. Then finally, think we are not.
No. What happened in the review?
Review. Review was dismissed.
The review
They are
was
challenging this review, the order of this review petition and also the writ petition. Earlier order passed by the writ court.
you file another writ petition.
Yeah.
Then
we preferred a writ appeal.
what happened in the review?
Then the lordship will find on page 35.
Yes. What happened? What
Lordship kindly see paragraph 5 or not.
we are of the firm opinion. Respondent number 6 was not entitled to invoke the writ petition of the court for seeking a direction of demolition of the construction raised by the appellant due to the his own property. The interstate dispute between respondent number 6 and the writ petition that will be passed by the court. It would be to entertain such a practice. We have it seems the respondent was suspected of taking Then
Then Lordship kindly see page 46.
45. Directed to the authority of.
This committee was constituted.
Then
46, 16/6/2023. Again, the same order they have passed in earlier. Similar order was right.
what is TDA?
Tinsukia Development Authority.
Approved by TDA is this.
Yes, earlier there was TTA 2011. My permission was TTA in 2011.
Found during site verification. Is
There's some deviation was found. My grievance is a separate in pursuance of the readable judgment.
Then
Without taking into consideration that if any deviation is found, the honorable division means directed that may be compounded. Then
no, Mr. Doctor, tell me whether this is can be compounded.
yes,
Can it?
yes, 2000 regulation.
Wait.
Regulation 5, it's 9. I constructed with some deviation is there. It's within my boundary. Regulation 9. With the heading of penalty.
Regulation 9. Yes, 9.
Yes, Lordship will find that some compoundable items are there.
Okay.
Coverage area, side setback, etc.
Yeah. Tell me. This is what? Constructed in violation of the approved plan.
Here. So therefore, Lordship will find that if there is some deviation from the approved plan, then this compounding part and they will have a right to impose penalty.
No, not only penalties, but if it is appellate 80%.
And therefore, the division bench,
penalty.
honorable division bench has directed
Interior approved is 840. We have made 1163.
yes, there's some deviation.
Then?
There's some deviation. But that can be compounded
How?
by applying this rule 9, the regulation 9.
Rule line understood that the plinth area will be on the basis of the part. The coverage is,
Yes, 50%.
is permissible out by 15%
15%.
maximum.
15%.
Then it is 323.
Therefore, what we
Is
pray before the
Mr.
authority,
Doctor, is 323 out of
Lordship, I understand.
840. Is it 15%?
it's a 22%.
Then?
No, my prayer before the authority was that you please consider how it can be compounded and how much portion to be demolished. And therefore, I filed representation before the authority on 11th of July 2023, saying that the division bench is directed not only carry out a field verification, but also see the aspect of the compound. So please explore that part also. Without exploring that part, we came to a final conclusion, giving us an appropriate hearing. So they carried out. They are now going to carry out the demolition process. That is my only grievances. Lordship may please direct, if your Lordship deem it necessary, that in pursuance of the division bench judgment, they may be considered that part of Lordship as per law. Without considering that part, they are only comply with the one part. There are two aspects of the order as past para 8 of the division bench. That my only respectful submission to the law. That may be looked into by them by disposing this read application at this moment. If your Lordship.
issue notice, making it returnable on 30/8/2023.
Can it be on 21st?
No. 30/8/2023. Mr. S. Purua, you appear for town and planning?
Yes, I appear for 1, 3, and 4.
3? Not 3, 1 and 4.
Executive officer, many a time we appear, but not
If
the
you are appearing, then not, why not 2?
municipal board for the chairman, we don't appear. Because this is an.
No. How can you appear for executive officer? Is it the same Tinsukia Municipal Board?
Is the
Official of the municipal board of.
He is the executive.
He's of the
So
municipal board.
let notice.
Appears on behalf, Mr. S. Bolwa appears on behalf of the respondent number 1 and 4. Extra copies of the writ petition be served upon him by 27th of July, 2023. As regards the respondent numbers 2, 3, and 5, steps be taken by way of registered as well as usual. The petitioner is further directed to take steps upon the respondent number 2, and 3 by way of dusty. All of you stay together only. Upon 2, 3, and 5 by way of dusty, routed through the registry of this court, and file an affidavit of service on or before the next date. The learned senior counsel appearing on behalf of the petitioner have sought for a stay to the demolition notice dated 16/6/2023. Stating inter alia that the respondent number 2, while issuing the said demolition notice, have not taken into account the judgment of the division bench of this court dated 23/3/2023, passed in writ appeal number 41/2023. I've heard the learned counsels. It appears from the judgment and order dated 23/3/2023, passed in writ appeal number 41/2023 and 46/3 and 63 writ appeal number 63/2023. That the division bench of this court had duly observed in paragraph number 5 that the dispute between the petitioner and the respondent number 5 herein, bracket here, respondent number 6 in the writ appeal, was purely a private dispute for which the writ proceedings ought not to have been allowed to be initiated. The division bench of this court further, in the said judgment, had also observed that paragraph number 8, which is reproduced here in under page 43, property. From a perusal of the said paragraph so quoted above, it reveals the liberty was given to the respondent number 2 to get a fresh field verification report prepared by following due process of law and by allowing opportunity of participation to all concerned. It was further observed and directed that after verification as per procedure, if any deviation was noticed in the construction raised by the petitioner, bracket the appellant therein, the same shall be dealt with as per law, which would include an opportunity of compounding the deviations, if any, as per law. The Learned Senior Counsel has submitted that pursuant to the same directions, although an order was passed by the chairman of the respondent number 2, for carrying out of fresh field verification report, for fresh field verification. But the respondent number 2 board failed to take into consideration the direction passed by the division bench to the extent that if there is a deviation, the same shall be dealt with as per law, which would include an opportunity of compounding the deviation. The Learned Senior Counsel has also further drawn the attention of this court to the, what is this?
Zoning Regulation 2000.
Starts from where?
From the past page. Past page, Lord.
Zoning regulations. So made in terms with the Assam Town and Country Planning Act 1959, wherein clause 9.2.1 have stipulated certain compoundable items as well as non-compoundable items. The Learned Senior Counsel had submitted that the deviation so mentioned in the impugned communication comes within the ambit of the compoundable items. And in that regard, the appellant, the petitioner, had submitted representation to the chairman of the respondent number 2 board, which have not been taken into consideration. This court is prima facie satisfied that a case has been made out by the petitioner for stay of the demolition notice dated 16/6/2023 till the next date. This court is also of the opinion that if the demolition is carried out without any considerations to the zoning regulations, the same would cause irretrievable injury to the petitioner. The balance of convenience also is in favor of the petitioner, taking into account that if during the pendency of the instant writ petition, the demolition notice, impugned demolition notice dated 16/6/2023 is acted upon, the same would result in demolition of the building of the petitioner. And thereby causing hardship to the petitioner. Considering the above, this court therefore stays the demolition notice dated 16/6/2023 till the next date. The respondent number 2 is directed to apprise this court on the next returnable date as to whether the deviation so mentioned in the demolition notice can be compounded and or to what extent it can be compounded.
Great.
Yes, take this. It's in a very shabby state.
From the website only.
Item number 20, court number 7.
Because he has not mentioned it. No? Please the matter again on Friday.
All right.
Item number 21, court number 7.
Yes, Mr. Dhar.
What if the NIT was invited Lordship Pursuant on 24/5/2023, and pursuant to that NIT, Lordship, the private respondent number 5 was illegally settled with the market law.
Who?
Private respondent number 5 was illegally settled with
You
the
are?
market.
I'm on behalf of standing counsel of PT.
Fantastic.
Lordship, you will find the NIT at page 16.
No caveat.
Okay, BT. And the mandatory requirement is clause 8 of the state NIT.
No, wait.
Lordship.
There is a settlement for market.
Lordship,
Which market we are concerned?
we are concerned with the Lordship will find at page 19. Page 19, item number 10, Dotma Weekly Hut.
Dogma Whitley Hut. Okay, now let us see what are you alleging?
Firstly, Lordship, at page 16, the NIT. Page
Yes,
16 is the NIT, Lordship.
page 16 is the NIT. Tell
NIT
me.
dated 24/5/2023,
Hmm.
and mandatory requirement is clause 8. The
Shall attach to the
Yes.
tender with the following documents.
Lord.
Bank draft originally. Now, what is your allegation?
allegation is that he has not complied with the tender process.
What is your allegation means?
Allegation, Lordship, I offered a bid amount of rupees 1,85,750,
1,85,000.
85,750. And the
Ah.
private respondent number 5 has offered 1,05,405.
Bid value.
Lordship, will find at page 20, this is the banker check, which was banker check of the petitioner.
Dogma. And it has been given to whom?
Given to the private respondent number 5, Lordship.
Why?
But
Yes,
Lordship
what
will
is
find
this?
at page 22, annex 3.
Don't tell me you are not opening the file. You don't think that?
My lord, I have not received the petition copy.
No.
So
We have given 2 copies, Lord.
Even 2 copies.
For amendment question also, we have given 2
I've
copies,
got
Lord.
this time only. My
Right.
lord. That is the problem.
Let us see the hey copy control.
To move.
The copy is there 90.
Here, Lordship, comes to page 20 to the comparative statement, Lordship.
R.K. Musahari, who is he?
Is
Who is R.K. Musahari?
R.K. Mutari is a petitioner.
No. Is the standing council petition.
You don't know. You have petitioner councils, BTC councils.
Standing counsel.
I have been instructed by my senior,
Who is your senior?
senior Esther. He told me to fix it just after 2 days.
Right.
Because he's no.
You only ask, you know R.K. Musahari? Do you know R.K. Musahari or not?
I don't know actually.
এইখানে টিকাটো লগাই দিও RK Musari, let him come.
He is out of station now.
We'll take him. We'll get
Mr. Choudhury was to come, Lordship.
no, we'll ask RK Musari to come. We'll see.
RK Musari is out.
এখানে এইটো লগাই দিও। We wait for Mr. Thar, wait for some time. We'll get hold of him, then we'll pass for it.
But there is a standing order of the BTC, Lordship.
Whatever may be, we'll get hold of the RK. Next,
Production list, item number 1, unlisted.
yes, Mr. Ahmed, your matter.
Lordship, can it be taken up after some time? Mr. D. Nath is appearing.
What is this matter about?
Matter is with regard challenging the NIT which has been issued by the Fishery Department on the terms that some conditions which are not at all feasible as per the directives and the notification issued by the Finance Department. So the petitioner is not eligible to participate on those grounds, and accordingly he didn't participate, and finally in the last hour, at the 11th hour, he has approached the court. The NIT will be open at 2, and he has come to know about that NIT on 16. From 16 for last 10 days he had been sitting.
16 what?
16th of this month.
What is, where is the NIT?
Page 18.
Yes, correction.
10th of July. 10th of July.
Published on 16.
Now, what is the offending clause? For general information that the seal tender will be received up to 1:30 p.m. of 24th July. Today is 25th. It was till yesterday.
Queries in them.
As earlier, due to unavoidable, it will be 25th of July, 1:30, undersigned, and the tender box will be open on the same day at 2 p.m. in the conference hall. Now tell me, why you are challenging it?
Lordship, this is a violation of the office memorandum. Page 20.
Have you made the finance department a party?
Yes.
Where's the finance department? SC Finance? Okay, tell me, what is it?
NHFO at page 20. The office memorandum.
The partial modification of the office memorandum dated remark the governor of Assam is pleased to re-notify clause para 4 and para 6 of the office memorandum dated when all administrative departments of and procurement for services and work for all tender values of rupees 20 lakh. However, the following actions remain exempt. Yes, who are you?
Lordship, I am also a supplier dealing in feed.
Then why didn't you submit? How are you aggrieved?
Lordship,
How are you
the
aggrieved?
entire tender is vague, nothing has been said. It is absolutely against the provisions of the Assam Public Procurement Act.
I understood. I have looked into it. But tell me, how are you aggrieved?
I'm aggrieved because I cannot participate
Why?
in terms of what has been stated.
Why?
terms have not been given, they only said that details can be seen in the office.
That is different. I'm not on that, but I'm only asking you, how are you agree? Everybody else is submitted.
Only interested parties were favored by the department.
And there is also another petition filed by you.
Yes.
Relating to what?
Similar in different districts.
Then what happened?
We got an interim order there.
Having relying on the so and so for the petition to the estimate value of the supply demand, the same is found not being conforming to demand. The intent is inclined to direct the response to the NIT petition so and without the. So you want similar order?
Similar order, only I want an inquiry also.
But it's okay. Yes, finance. Mr. Burma, let them go ahead with the tender,
Yes.
not to finalize it.
Yes.
Okay.
That will be.
How much time do you require for your instructions? We'll have it soon. Why did I'm taking up this matter?
Yes.
Otherwise, this matter takes only 5 minutes for disposal of this type of matter. He wants a similar order to that effect. You go ahead with the tender, but don't finalize it till the next day.
Yes.
When can you, as fast as you can do it? What happened to this matter yesterday? This 24/7, this matter, what happened, Mr. Ahmed?
Time has been taken and stay has been allowed. Up to second of.
You are not interested?
I'm not sure about that other one.
Where is Mr. Dinath? And yes, finance, what is this? Explain this about this thing.
The finance notification.
But how are you aggrieved? I am not understanding, Mr. Ahmed.
Your Worship,
You know about this thing. Why you are not participating? I'd have understood that some people coming out there and saying, hey, look here, I didn't know about it.
Yes.
You knew it.
you knew. I knew
Yeah.
it, but again, Your Worship, how can I participate in a wrong anything?
That can't be the reason why. You have to show it. Why should I court issue a writ of certiorari without there being the prejudice being caused? No prejudice being caused to you.
Your
Why
Worship, I
should
am
this
because
court at all stay
I-
or stay or do anything to that? Why haven't you participated? You knew about this thing. When did you come to know about this thing?
16th.
Huh?
16th.
It is 16.
If you have come to know about this thing, why you are ending it at this hour?
From 16 till today is
We
25th.
submitted the representation that, yes, we submitted the representation.
No, forget about the representative. You knew about this thing. Why haven't you submitted your tender if you are interested at all? You are interested to get it. E-procurement is given for what? Yes, finance.
Fish seed.
And is this necessary for urgent requirement? Fish feed.
Lordship, this
No.
is for transparency only, Lordship, because everything is done through the e-portal so that everybody can participate.
No, does it come within the urgency clause?
No.
Why not? Fish feed.
Fish feed is urgent, definitely. There is a period within which that has to be shown.
Fish has to be urgent.
They have to mention everything.
How are you aggrieved? I'm not concerned. I would have understood somebody else coming in, saying that there is a e-procurement thing, the finance does it and yeah. But who are you?
He's no one. He didn't participate. He's
You
not aggrieved.
impose.
I've been a
And he has come in the last hour to just.
Mr. Ahmed, I dismiss the petition with the impost.
No, I've participated earlier. I've been always.
What is the value of the contract?
Value of the contract is more than 20 lakhs.
Huh? More than
30 lakhs,
20 lakh.
30 lakhs, 80.
Okay, we impose a cost of 2 lakhs. 2 lakhs. No, this court is not inclined. We dismiss with cost. because you knew it. How are you aggrieved? You have to show me how are you aggrieved. You're not aggrieved. There might be a case of this. I would have understood some other things. Here is a case of this thing, what you call fish feed. Fish feed is the fish has to have it. Are hereby invited by the undersigned for registered suppliers who have to supply the following materials under the scheme: input for fish farming in new ponds and input for integrated so and so with money in the so and so, so and so, so and so. The tender will be received at the amount of so and so and will open at 2 p.m. at so and so. Estimated fish feed for only for activities of input for fish farming. Then fish, what will the fish have? Livestock feed.
The tender itself is wrong. It's in violation of the legal provision.
Understood. The violation is there. Somebody else may very well come who has been affected, but you knew it.
No, I knew it and that's why I represented. But they're
So
not-
what?
they're not-
How is it relevant? Is it does it help you in any manner if you are submitting through e-portal? Tell me. How is it beneficial to you if it is in e-mode?
If you open competition, I am a regular supplier. I've been doing it for last so many years.
So
And now here they're trying to favor a few people without following it.
understood. How are you aggrieved?
Agreed in the sense that I'm being denied.
Denied
will
for
be
what?
denied.
You knew about this thing. Why didn't you participate?
I will be denied by the department. And
Oh, that is too much. Apprehending something which will happen something else. You have various other reasons to approach. If there is a denial for you being the highest tenderer out there or whatever maybe, or the lowest bidder out there, you'll obviously have a right over it. But how you knew about it?
no bid documents have been issued.
This is there in the notice. Seal quotation in plain paper. What is required? Seal quotation in plain paper affixing port fee stamp of 8.25 are hereby invited so and so. That's all.
That
The
is,
detailed terms and conditions of the is available in the office, which may be seen during the office hours. Go and look into it. Separate item-wise tender will also be accepted by the underwise. So it is already there. I don't see any reason for interfering. We only see a reason for dismissing with cost. Cost
which
of-
documents need to be given as per the act?
No,
Yes,
where is it?
the Assam Public Procurement Act 2017.
Show me.
I'll give this. That will be
Mr. Ahmed, 4D is relating to procurement planning.
And then no, there procedure even.
No, here it says the procuring entity shall publish the procurement plan prepared pursuant to subclause 4 of this section on the state public procurement portal and in the website of the procuring, provided that the publication of the under this clause shall not be construed as initiation of the procurement process and cast any obligation on the procurement to issue bidding document or to confer any right on the prospective bidders.
And 13, the single envelope and 2 and 3.
You have not brought on record the terms which are there. Have you taken out the terms? Have you gone there to his office and got the separate, the detailed terms and condition is available in the office? Have you gone there?
We've gone, we've been.
Have you got the
they-
detailed
they-
terms and conditions?
No, they don't give the detailed terms and conditions, only on the notice board.
Yes, who is appearing for here? You don't give detailed terms and conditions.
It was given a bypass to this, earlier they followed this procedure.
In
I
fact,
could tell you.
He on what terms he was having a doubt as regard where he have approached the office, that's not clear here.
That
What
is
did-
why I am saying.
Yeah.
He says that the detailed terms are not given when you go there, where it is being mentioned out here in the short notice inviting quotation that the detailed terms and conditions of the tenders is available in the office, which can be seen during office hours.
Definitely that has to be there because
Hmm.
ultimately without that being so, how
Hmm.
can that be added in the NIT?
This is previous, earlier tender done according to procedure as per the act. 2019.
So you participated in this
Yes.
Huh?
Yes.
and you got this.
It's successful.
Show me those where you have got it.
That I haven't got that. But I haven't wrote that here.
And,
I can produce earlier.
Mr. Amin, I'm not satisfied. I'm dismissing the petition.
But they cannot be allowed to give a tender in this form.
Huh?
They cannot be.
You have my approach now. I'm dismissing the. Now, only thing is, while dictating the judgment, I will consider how much is the cost. Okay. The instant writ petition has been filed, challenging the notice inviting quotation dated 10/7/2023 and also for a direction upon the respondent authorities to dispose of the representation dated 21/7/2023 and for directing an inquiry through an independent agency for violation of the extant law. The facts involved in the instant case is that on 10/7/2023, a notice inviting quotation was published a short notice inviting quotation was published thereby inviting from registered firm oblique supplier to supply the materials mentioned in the said quotation under the scheme inputs for fish farming in new pond construction and inputs for integrated fish farming under PMMSY for the year 2022-23, along with money deposit bracket EMD in the form of demand draft, oblique term deposit, oblique FDR, oblique call deposit, etc. from any nationalized bank in favor of the District Fishery Development Officer, Dorong Mongoldoi, on estimated amount at the rate of 1% in the case of SC oblique ST oblique OBC oblique MOBC and at the rate of 2% in the case of general category supplier. It was mentioned in the said short notice inviting quotation that the tender would be received up to 1:30 p.m. on 24/7/2023 and would be opened at 2 p.m. on the same day at the office of the District Fishery Development Officer Dorong Mongoldoi. In presence of the tenderers or their authorized representative. Further to that, in the said short notice inviting tender, it was mentioned that the detailed terms and conditions of the tender are available in the office of the District Fishery Development Officer, Dorong Mongoldoi, which may be seen during the office hours. It is relevant to take note of that there were various items in which were to be the supply for which the said notice inviting quotation was published. As regards the items at serial number 1, 5, and 6, the estimated value was rupees 6,80,000, 28,000 and 30,000 respectively. However, as regards the item at serial number 4, which is formulated fish feed, bracket 4 mm, pelleted, PELLETTED, with 26-28% CP, bracket again open, floating 50% and sinking 50%, bracket closed, of a quantity of 49,565.22 kgs of an estimated value of 22,80,000. It further appears that there was a corrigendum issued on 16/7 corrigendum issued, which was published in the SMS News Daily on 21/7/2023, wherein it has been mentioned that the period of the last date for submission of the tender was fixed on 25th of July 2023 till 1:30 p.m. and the tender box would be opened on the same day at 2 p.m. in the conference hall of the office of the Deputy Commissioner Darang as per the direction of the chairman of the tender committee. it reveals that on 21/7/2023, a representation was submitted by various persons, including the assistant manager of the petitioner firm, alleging various anomalies, errors as regards the procurement made by on the basis of the short notice inviting quotation on 10th of July 2023. The petitioner herein which is a proprietorship firm, has approached this court the petitioners herein have approached this court by filing the instant writ petition today, that is on 25/7/2023, challenging the said short notice inviting quotation in respect to the item at serial number 4, in respect of which the estimated value is 22,80,000. It is the case of the petitioners herein that the office memorandum, there is an office memorandum of the finance department of the government of Assam, wherein it stipulates that all administrative departments of the government of Assam and its subordinate directorates, offices, agencies, etc., bracket, including institutions receiving granting aids from government of Assam, bracket close, shall adopt e-procurement, bracket, http://assamtenders.gov.in, bracket close, for procurement of all goods, services and works for all tenders of value of rupees 20 lakhs and above. However, in respect to certain categories, the said mandate have been relaxed. It is the case of the petitioner that, taking into account that the item at serial number 4 is of the value, has the estimated value of rupees 22,80,000. The said tender process so initiated on the basis of, what is that? What do you say this type of tender? And this is not e-tender. Normal tender is what? Offline tender.
Actually, the other one, that e-procurement,
This is what?
the E10,
This is what?
it's got in, and I in short note.
What is the offline tender? Offline mode. By offline mode was contrary to the office memorandum of the finance department, and as such, the said tender process in respect to serial number 4 should not be allowed to be continued. Yes, Mr. Naik, what do you have to say on this finance thing? You are a finance.
Lordship, that notification was issued by the finance department, it is there, Lordship.
Hmm.
But in some cases, Lordship, where some technical difficulties are there, some departments are still going for offline mode now. That is there.
Would fish feed,
Not,
this is fish feed,
not
would come within the ambit of an urgent requirement.
probably not. It's an urgent requirement for the sitting purpose. And that is why Lordship, I am saying that tender was also a short tender, Lordship. I mean, it was issued on 16th, it was published, and last date was given 24th of July, only 12 days.
Mr. Pinack, appearing on behalf of the Finance Department of the Government of Assam, submitted that the Finance Department had issued the said office memorandum on 10/6/2023. However, in respect to emergency procurement and urgency works, there is an exemption in respect to procurement of goods, services, and works for all tenders of value of rupees 20 lakhs and above. He, however, submitted that this exemption would not, however, work in respect to procurement above 50 lakhs, as could be seen in serial Roman 3, isn't it? Wherein it is mandatory for making procurement only by way of e-mode. The Learned Counsel for the Finance Department further drawing the attention of the short tender notice. So notice inviting tender quotation submitted. That this short notice inviting quotations are normally issued when there is an urgent or emergency requirement of certain goods. Mr. S. Burwa, appearing on behalf of the Fishery Department of the Government of Assam, have submitted that from a perusal of the writ petition, it is apparent that on 16/7/2023, the petitioner had due knowledge about the said notice, short notice inviting quotation. The petitioner further knew that today is the last date for submission of the tender, and by 1:30 p.m. and at 2 o'clock, the said tender would be opened. And the petitioner has now invoked the jurisdiction of this court by filing the instant writ petition. And as such, on that ground itself, the petitioner, it disentitles the petitioner to the relief so sought for. The Learned Counsel further submitted that the petitioner has not shown any prejudice or cause to him on account of the said tender being the said procurement in respect to the goods at serial number 4 been done through offline mode. Inasmuch as the petitioner, having known about the same on 16/7/2023, could have very well submitted his tender. He therefore submitted that the instant writ petition is not bona fide and accordingly should be dismissed with exemplary costs. The Learned Counsel for the State Fisheries Department further submitted that though a coordinate bench of this court had passed an order on 13/7/2023 in respect to WPC number 3977/2023. However, the said interim order cannot be applied to the facts of the instant case when the petitioner has approached this court at the 11th hour. I've heard the learned counsels for the parties and have perused the materials on record. It appears from a perusal of the petition itself that the petitioner knew about the short notice inviting quotation on 16/7/2023. He further knew on 21/7/2023 that there was a corrigendum issued stating inter alia that on 25/7/2023 at 1:30 p.m. would be the last date that the tenders could be submitted. And at 2 p.m. of the same date, the tenders would be obtained. The petitioner having not However, it is seen that the petitioner have filed the instant writ petition only today. And as such, in the opinion of this court, it disentitles the petitioner to the relief so sought for in respect to relief so sought for. Further to that, be that as it may, it is also relevant to take note of that the office memorandum dated dated 10/6/2023. Is it 9 or 10? It was signed on 10.
Nine.
But signed on 10.
That's
Na?
signed on 10.
So it will become effective from when?
10.
The office memorandum dated 9. These office memorandum has different things. You see, I think your people should be more careful. On top it is said 9/6. Signed on 10/6. Down below it is 9/5. It is further seen from the office memorandum dated 9/6/2023, which was signed on 10/6/2023, that for procurement of all goods, services and works for procurement of all goods, services and works of all tenders of value of rupees 20 lakhs and above, the same should be adopted through e-procurement mode. It is further seen that there's an exemption whereby all emergency procurement and urgent works as defined in the Assam Public Procurement Rules 2020 are exempted from the purview of the said amendment. Full stop. Where can I get the rules?
Yeah.
You have the rules?
Urgent work have been defined.
It is also relevant to take note of that section, that rule 2I defines emergency procurement to mean procurement of goods, services, or works that need to be taken up in response to recent or imminent, natural or man-made disasters and calamities to restore public facilities or services which are crucial for reinstating normal public life. Rule 2S defines urgent works as distinct from emergency works to mean works which require immediate commencement or completion within a very short compressed time schedule, or which need to be taken up on priority basis in public interest to ensure the safety and security of life or prevention of loss of public assets. In the opinion of this court, taking into account The item at serial number 6. Which is fish feed. Fish feed. And the issuance of a short notice inviting quotation. And the manner in which it was done. For obtaining the same, for procurement of the same on priority basis. This court is of the opinion that the same would come within the ambit of the exemption of urgent works as defined in the Assam Public Procurement Rules 2020. Another very relevant aspect of the matter which needs consideration is that from a perusal of the writ petition, it is not nowhere disclosed as to how the petitioner herein is prejudiced by the short notice inviting quotation. Inasmuch as the petitioner very well knew on 16/7/2023 about the short notice inviting quotation, and the same was further extended to 25, and the last date was further extended to 25/7/2023. The filing of the writ petition at the 11th hour, that too at the eve of opening of the tender, in the opinion of this court, does not inspire the confidence of this court that the petitioner have approached this court bona fide. Taking into account the above, this court does not find any merit in the writ petition, for which the writ petition stands dismissed.
One thing, the previous order, the order given by in the there was an earlier writ petition that has been cancelled by the government
When?
on 17. Okay.
But he approached this court on earlier by filing a writ petition.
That's true.
Then
Yes.
they have done it very well.
There is no urgency. It's evident from this. Right.
Item number 14 of court number 7.
Mr. Thorough matter to Asini. Where is the on until PTC.
I informed Mr. B. Chaudhary, and he came, Lordship, now again I bring him up.
I may be allowed to call Taiwan, sir.
Okay.
Item number 14.
Oh, you both of you are not there. Okay, we take up other matters. You get hold of yes, Mr. Manan, your matter.
Lordship, I'll inform the Mr. B.
Take it up at 2. Ask him. Yes, Mr. Manan, what case you have?
This
Item number
actually,
1.
I have
of
gone
Court number
through-
17.
I have lost the file. I've gone through the file from my learned friend. I think this matter doesn't deserve to be interfered with. It should go. Otherwise, because the allegations that has been made are not proved. In fact, the date was the 21, I think it was 21/12/2010 at Pittsburgh. Then, your lordship, they were, no doubt, they were successful. But from the affidavit, what I have seen, that the total that the marks, cutoff marks is 65 for OBC. And they are admittedly at 53, 56, 53.5 and 62.5. Then, your lordship, and there is an allegation that persons who are not even successful were
But you have not
appointed,
made
but there
them
is no
parties.
proof.
You
So I
have not
think it
made
should
them
go.
parties also. And
that's
in
it.
fact, on the last occasion when the matter came up, long
Yeah,
time
long-
back, 9 years back,
Yes.
then you said that this has to be taken up with another repetition.
That has been
That has also been dismissed.
dismissed for actually not taking steps upon the response. I don't think unnecessarily I will also not argue any this.
So what to do?
So people dismiss it. But at least not submit. I have submitted.
Obviously. The instant repetition has been filed. Challenging. The select list. Dated 8/2/2010. Following that, no. Challenging the select list dated 21/12/2010.
21/12 is the advertisement.
What is the select list dated?
It is 21/12 is the select. Advertisement is 8.
Challenging the select list dated 21/12/2010, which was published in the Assam Tribune. The facts can be discerned from a perusal of the writ petition is that on 8/2/2010, an advertisement was issued by the Additional Director General of Police (TAP) Assam, Ulubari, Guwahati, for filling up of 3,843 numbers of vacant posts of AB Constable, including 637 numbers of backlog vacancy of AB Constables. In the said advertisement, 10% of the vacancies were reserved for women, and other reservations are 27% for OBC/MOBC. The petitioners herein are all OBC category, belong to the OBC category candidates. And applied in respect to Morigao district. It is further relevant to mention that for Morigao district, the total vacancies were 74. As many as 1,600 numbers of candidates had participated in the said selection process insofar as the Morigao district is concerned. The petitioners claim that they have performed the physical efficiency test to the best of their ability and thereupon had also performed well in the interview. The petitioners were expecting that they would be selected in the said selection process. However, the when the select list was published in the Assam Tribune on 21/12/2010, the petitioners were shocked and surprised that they were not selected. The petitioner thereupon met the petitioner thereupon being aggrieved have filed the instant writ petition by challenging the said select list. It is relevant to take note of that although there has been certain allegations being made of bias, or for that matter, that some of the candidates were not qualified, but none of the selected candidates were made parties to the instant proceedings. We'll give remaining at 2. It reveals from the records that on 8/4/2011, this court had issued rule and directed that the instant writ petition be listed along with WPC number 1086/2011. The records further show that an affidavit in opposition was filed by the respondent to the Deputy Superintendent of Police HQ, Morigao. In the said affidavit in opposition, it was mentioned that in the month of February 2010, an advertisement was published in various newspapers for conducting a recruitment rally for selection of candidates for appointment as AB Constable in Assam Police against 3843 posts. It was stated that the number of posts allotted for Morigao district was 74 only. The recruitment rally was conducted as per the laid down procedure, and the final selection list of the candidates was prepared purely based on total marks secured in the physical efficiency test and in the interview. The number of posts, it was further stated that as per the reservation policy and the total marks secured, the final selection list of the candidates was prepared by the district level selection committee and sent to the state level police recruitment board for approval and publication of the result. After scrutiny and approval by the state level police recruitment board, the final selection list of Morigao district was published by the state level police recruitment board. To the said affidavit in opposition. Now, in the said affidavit in opposition, it was further mentioned that the cutoff marks for the general category candidates were 65.5 semicolon. For SC candidates, 64. STP semicolon, STP 65 candidates 65. STH category 59. OBC candidates 65. For female 68. To the said affidavit in opposition as annexure Roman 2, the marks so obtained by the petitioners, who all belong to the OBC category, were given in details. It reveals from the records, it reveals from the said document that the petitioner number 1, 2, 3, and 4 were awarded 53.5, 56, 53.5, and 62.5 marks respectively. And as such, they were below, and as such, their marks were below the last selected candidate in the OBC category who obtained 65 marks. It further reveals that all the selected candidates all the 74 selected candidates, the select list of all the selected candidates were also enclosed as Annexure 3 to the said affidavit in opposition. This court further finds it relevant to observe at this stage that the said affidavit in opposition was filed on 2nd of August 2013. But thereafter also, the petitioner did not take any steps either to implead the selected candidates insofar as the Morigao district is concerned. In the backdrop of the above materials on record, this court finds it relevant record. And upon hearing the learned counsels for the parties, the issue which arises for consideration is as to whether number 1, whether the instant writ petition is maintainable without the selected candidates being made parties to the instant writ proceedings, taking into account that the entire select list has been put to challenge. Number 2, as to whether the petitioners hearing, after having participated in the selection process and finding that the results was not palatable to them, can approach this court by initiating approach this court under Article 226 of the Constitution. कितना से अपना जजमेंट दिছিল disposed of করা এইখিনি প্রায় এই দুইটা কিন্তু উল্টা করে দিব কোশ্চেন তো ফার্স্ট টু ফর দিব সেকেন্ড টু the first question to hey খিনি এটা আমরা আনি এখানে লিখলি Kita pra itu ani itulay Tanbir Modi. Itu kod gol judgment tu. Tanbir Singh Sodhi. Ikne ka likhi 69 paragraph tu ani. In the backdrop of the above, law as settled by the Supreme Court in the above mentioned judgments and applying the same to the facts of the instant case, it would be seen that the petitioners herein have taken part in the selection process without any demur or protest. The pleadings of the petitioners further show that they were expecting that they would be selected and the present petition has been filed challenging the selection process as the results of the said selection process was not palatable to the petitioners. This court is of the opinion that the petitioners in the instant cases could not have questioned before this court the selection process after having participated in the said selection process without any demur or protest. This court further finds it also relevant to take note of that there are certain allegations being made in the petition, in the writ petition, as regards bias, or that certain candidates were not qualified. But such allegation so made are without any material particulars as regards the persons without any material particulars. And as such, in the opinion of this court, the same cannot be gone into in the present proceedings. Next. This very aspect of the matter touches on the second question so framed, as to whether the instant writ petition would be maintainable without making the selected candidates a party to the instant proceedings, taking into account that the entire select list has been put to challenge. It is relevant to take note of that the selected candidates as submitted by Mr. S. Bolwa, appearing on behalf of the respondents. Upon being selected, have been duly given, were appointed, and have been discharging their duties a valuable right have therefore accrued upon those selected candidates. It is the opinion of this court that without affording an opportunity the right which is accrued on the basis of a selection so conducted cannot be nullified. Under such circumstances, in that view of the matter, this court, having decided both the issues against the petitioner, the instant writ petition fails, for which the same stands dismissed.
In the court, second copy.
You are lucky to get a second copy. There are in 2011, in the first copy, both the first copy and the second copies are kept. You are lucky.
Anyway, I was expecting what I have seen from the court. Much of like.
Item number 21, timing, court number 7.
So he has not come.
If you take your lordship to page 16, this is the election 1. This is the NIT lordship.
Issue notice.
Lordship, one thing, lordship, there is a standing order of the BTC lordship. This is the standing order.
What is that?
It is issued by the joint secretary, BTC for the lordship, that the highest bidder should be given the what?
Not necessary. Issue notice. You want to bring it by way of an affidavit. Issue notice making it returnable on 30/8/2023.
The appeal order is at page 24.
Mr. B. Chaudhary represents the respondent number 1, 2, 3 also. Deputy Commissioner BTAD.
No, Lordship, even
1, 2, and 4. 4, na?
Yes.
4. Mr. S. Bolwa appears for respondent number 3.
and Gusami.
The council, therefore, the petitioner is therefore directed to take steps. Extra copies of the writ petition, therefore, be served upon the learned counsels appearing on behalf of the respondent number 1 to 4 by 27th of July 2023. As regards the respondent number 5, steps be taken by way of registered as well as usual by 27th of July 2023. The petitioner is further permitted to take steps upon the said respondent number 5 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next day. The learned counsel appearing on behalf of the petitioner submits
Page 23.
that
sir.
a perusal of the tender notice dated 24/5/2023 stipulates at clause number 8 that various documents are required to be submitted, are mandatorily required to be submitted. It is the allegation of the petitioner that the respondent number 5 have not submitted the income tax oblique GST, the non-encumbrance certificate, the Bakizai clearance certificate, as is required under clause 8F, non-encumbrance will be C, huh?
Lordship,
8CF, no, 8F, G, and
and K lordship, Pakistan. At page 17.
and K. Full stop. The learned counsel for the petitioner have also submitted that the petitioner's bid value, the petitioner who had complied by submitting all the required documents as is required under clause 8, is also the highest bidder, as the petitioner's bid was rupees 1,85,750, whereas the bid value of the respondent number 5 was rupees 1,05,405. It is therefore the submission of the petitioner that the settlement so awarded to the respondent number 5 in respect of the Dotma weekly market for the year 2023-24 by the Block Development Officer Dotma Development Block Dotma dated 7/7/2023 is required to be interfered with. Upon hearing the learned counsels for the parties and taking note of the comparative statement enclosed as Annexure 3 and the bid at which the respective bid values of the petitioner and the respondent number 5, this court is of the opinion, is prima facie of the opinion. Now, this court is prima facie of the opinion that the petitioner has been able to make out a case for grant of a stay to the communication dated 7/7/2023 issued by the Block Development Officer, Dotma Development Block, whereby the settlement was awarded in favor of the respondent number 5 in respect of the market Dotma weekly market. Accordingly, the communication dated 7/7/2023 issued by the Block Development Officer, Dotma Development Block, thereby making the settlement in favor of the respondent number 5 for the market Dotma weekly market is stayed till the next returnable date. The respondent BTAD would be at liberty to run the said Dotma weekly market during the pendency of the instant till the next returnable date in a manner how are you going to run?
Lordship, the authority shall run. There is a notification, Lordship.
What is that?
Just now, my friend, authority will.
It is further made clear that till the next date,
No, Lordship, it will be the highest bidder.
so it is he will run.
He will run.
Why haven't you brought this document in?
Lordship, while filing the writ petition, I was not access to this.
Okay. Mr. B. Chaudhary, the learned counsel appeared in the state bill. Mr. B. Chaudhary, the learned counsel appearing on behalf of the BTAD. BTAD, na? Or BTC?
BTC.
BTC. During the course of the arguments, have placed on record an order issued by the Joint Secretary BTC dated 26/4/2023. From a perusal of the said order, it reveals that the BTC authority shall allow all such highest bidders of the concerned market, parking, ghat, etc., to operate the market, parking, ghat, etc., until further orders from the BTCN. The said communication, said order is kept on record and marked with the letter X. Taking into account the above, and as the petitioner, taking into account the above, this court directs the BTC authority to permit the petitioner to run the Dotma weekly market till the next returnable date, provided the petitioner is the highest bidder. Yes, Mr. Chaudhary, your matter.
My lord, there
is another order I am passing. Yes, tell me.
my lord, I informed Mr. Sahela yesterday, but I thought day after tomorrow.
So he is expressing urgency.
No, that's why, my lord.
Two officers from Baroda has come, my lord. Actually, this is a tender of Baroda.
Baroda's challenge here in Guwahati.
My lord, that is why, my lord, I'm saying, my lord,
That will satisfy me. That aspect that did arose.
that I shall satisfy, my lord.
No, naturally, my lord, it will also satisfy, we will also try to satisfy. Day after tomorrow, my lord. Actually, our reply is also not on record. We have filed an application for vacating stay, which we have filed objection today, my lord. Day after tomorrow, my lord.
11th day. Mr. Ken Chaudhary, the learned senior counsel, submits that a reply has been filed to the application seeking vacation, modification or alteration of the order dated
31/5.
31/5/23 has been filed today. The said affidavit is, however, not on record. Mr. G.N. Shahewala, the learned senior counsel, has expressed extreme urgency in the matter, stating that the said stay order is operating prejudicial, the extreme urgency in the matter. So, taking into account the above, let's matter again on 27th of July 2023.
April.
Timing item number 18.
The
of
only
court
thing is,
number
my lord,
7.
we have also filed an IA. It was till the returnable date. Our interim order will continue till day after tomorrow.
My lord, nothing will happen, my lord, till then.
Let it be there then.
Because already, my lord, we filed it on 26th of June. So 14 days expired long back, my lord. So we are not doing.
And then also
Till-
will
till
take care of everything day after
Yes.
tomorrow.
Yeah.
Timing item 18 of court number 7.
Lord, the bylaw I have procured, my lord.
See, now because of me, the president and the vice president knows about the existence of a bylaw.
My lord, page number 2 and 3, your lordship may see. 7(6)(a). The 4 days time is required to be given.
4 days notice of all meeting. এইখিনি এনেকে লেখক দেই আগৰখিনি মই সেই ফেক্টছ খিনি কলো তাৰপিছত কি আছিল ন এইখিনি এনেকে লিখিব নালাগে হা এতিয়া লিখিব এইটো এনেকে কৰিম The learned senior counsel appearing on behalf of the petitioner, drawing the attention to section 43(6) of the Assam Cooperative Societies Act 2007, submits that in terms with the bylaws, in terms with bylaws 7(6)(a), of the cooperative society, a notice, a 4 days notice is required to be given for all meetings of the managing committee, specifying the date, hour, and place. Full stop. The learned senior counsel submitted that it is only on 5/7/2007, 23, the in charge joint journal register of the cooperative society by the impugned order dated 5/7/2023 had stayed the communication dated 4/7/2023. And as such, the notice, the board meeting held on 5/7/2023 was contrary to section 43(5)(6) read with the bylaws of the cooperative society. 43(6) of the Assam Cooperative Society Act 2007 read with the bylaws of the cooperative society. The learned senior counsel further drawing the attention of section 34(5), 36(4) of the said Act of 2007, submitted that the board may by a resolution passed by 3/4 majority of the directors present and voting at a meeting held for the purpose, remove the president or the vice president. It is the specific contention of the petitioner, the learned counsel, senior counsel of the petitioner, that in the meeting held on 5/7/2023, how many directors were present?
8 out of 14.
Only 8 out of 14 directors were present of the cooperative society. And as such, The resolution dated 5/7/2023, on the face of it, was contrary to section 36(4) of the Act of 2007. The learned counsel further submitted. The learned senior counsel further submitted that if the resolution dated 5/7/2023 is not stayed, pending disposal of the appeal before the Register of Cooperative Societies, the purported chairman so appointed in the meeting held on 5/7/2023 would take action against the petitioners, which would be detrimental to the society. Mr. S.K. Talukdar, the learned counsel appearing on behalf of the register, on behalf of the corporation department, has drawn the attention to section 40, which one?
Regarding special meeting.
49,
49
49 2L. And submitted that in case of a dispute between the chief executive and the board in any matter, the decision of the register shall be binding on both.
There is a notification, my lord, of 2012, where under the power of under various provisions has been delegated to other authorities, but the power under 49 has not been delegated.
The learned counsel further referring to further submitted upon instructions that the power under section 49 2L reserved to be exercised by the Register of Cooperative Society had not been delegated to any of his subordinates.
By the notification dated 23/5/2012.
In that regard, he has drawn the attention of this court to a notification dated
23rd May 2012.
23rd of May 2012 to show that various powers of the Register of the Cooperative Societies have been delegated to his subordinates. However, the power under section 49 2L continues to be reserved to be solely exercised by the Register of Cooperative Society.
It is issued by the secretary, my lord.
He therefore submitted that the concerned respondent authorities, that is the Assistant Register of Cooperative Society, or even the in charge joint zonal Register of Cooperative Society, could not have passed the orders dated 27/6/2023 enclosed as annexure 9 and 10, as well as annexure, as well as the as well as the order dated 5/7/2023 encloses annexure Roman 13. He further submitted that it is only the register of the cooperative societies who could have taken a call or decided in respect to the dispute between which has arisen out of the communication, out of the board's resolution dated 16/6/2023. Mr. Monto, you are appearing for?
Respondent number 9 and 7 and 9.
And you? 6. Both of your submissions same.
My submission is that, my lord, I may be allowed to, my lord, produce the all 11 record and I may be heard, my lord, by the.
Who are you?
I am the one of the board of directors. And present president and vice president.
Oh, you have become the president.
My lord, what they have stated, my lord, that is their side, my lord. Your lordship, my lord, I am not on that, my lord, because he's in leave. He's in leave, my lord.
Understood.
3
But
months.
when did you become the president?
That is, my lord, meeting dated, my lord. That is meeting dated, my lord, 22/5/22/2023.
Where is it?
That is, my lord, not with me, my lord. He also not the next, my lord.
No, he's not there. You have to show us.
My lord, that is not with me, my lord. Right now, it is not with me. So that's why I'm submitting, my lord. I may be allowed to, my lord, produce all the relevant documents before the appellate authority, my lord.
On the other hand, I'm saying, by the resolution dated, you have participated in this meeting of 5/7? Did you participate? What's your name? 7 and 9, Jiten Das is there, 1 and 3.
5/7, my lord. Yes, my lord. 1 and 3,
Okay.
my lord. 1 and 3.
In that meeting, if you are the president and the vice president, how would you have said, adopted or signed in the resolutions wherein it has been mentioned that until the chairman of the so-and-so is authorized that so-and-so? It has been decided in the meeting that in view of the following, as Ranjit Das, chairman who is in collusion with the buyer, have illegally did. How did you sign this document? And be a part of the resolution if you are the chairman and the vice chairman or president?
That meeting I am not. That is in.
It is there very well. Your name is appearing at page 81.
Yes, my lord.
Then-
Yeah.
How did you sign it?
Then I have to take instruction on that.
Then
No, they're disqualified under section 37.
No, my lord, that is.
we are not concerned with that. So anyways,
That's why my submission before your lordship, I may be allowed to produce all the
Okay.
relevant document before the appellate authority, my lord.
that if you have anything, you go there. Mr. You are for 6. Your name?
ABT Hawk.
So and so. The learned counsel appearing on behalf of the respondent number 6, who is also on caveat, has submitted that as the appeal has been filed by the petitioners before the Register of Cooperative Society on 18/7/2023, and the next date is fixed on 28/7/2023, this court is not required to make any, is not required to take, entertain, or this court ought not to entertain the instant writ petition, inasmuch as a statutory authority is presently dealing with the dispute in question. Mr. T.J. Mohanto, the learned senior counsel, appearing on behalf of the respondent number 7 and 9, you were also in caveat?
No.
Who are you? How are you appearing?
On instruction, I may pay.
You
on-
you file a wakalatnama also.
Yes, Palak.
Don't
Yes.
tell me that. Don't ask him. He's for 6.
No, he's assisting on that.
He's for 6. Huh? Don't tell me you are assisted by 6. Huh? It will show a very sorry picture, Mr. Atmat.
He's assisting me, my lord, because yes,
6 is assisting 7 and 9.
council, my lord.
Huh? Mr. T.J. Montalaran, Senior Counsel, appearing on behalf of the respondent number 7 and 9, submits that he may be permitted to participate in the said appeal proceedings pending before the Register of Cooperative Society, wherein he would place the relevant materials before the said authority. First, upon here, perusal of the materials on record, I've heard the learned counsels for the party and perused the materials on record. From a perusal of the materials on record, it transpires that on 16/6/2023, the board of the cooperative society in question had resolved to remove the respondent number 6 in exercise of the powers under section 38(2) of the Act of 2007. A dispute therefore arose between the respondent number 6 and the board. A perusal of section 49(2)L categorically shows that it is only the Register of Cooperative Society who has the authority to decide a dispute between the chief executive, that is the secretary of the cooperative society, and with the board. It, however, reveals from the record that the Eastern Register of Cooperative Society, Tinsukia, have, on the other hand, without any authority, issued communications dated 27/6/2023 to the Eastern Register M of the Office of the Eastern Register of Cooperative Society, Tinsukia, to make necessary inquiry in respect to the board's resolution dated 16/6/2023, and had also issued another communication dated 27/6/2023, thereby suspending the board's resolution dated 16/6/2023, and till the completion of an inquiry, the respondent number 6 be allowed to carry out the function of the secretary. Taking into account section 49(2)L of the Act of 2023, this court has serious doubts on the exercise of the jurisdiction by the Assistant Register of Cooperative Society in issuing the communications, both the communications enclosed as Annexure 9 and 10, both dated 27/6/2023. It further reveals that the communication dated 27/6/2023, by which the board's resolution dated 16/6/2023 was suspended by the Eastern Register of Cooperative Society, was withdrawn by the said officer on 4/7/2023. immediately on the next day, another communication is now being issued, has been issued by the in charge journals joint register of cooperative society, thereby again putting the respondent number 6 as the secretary of the said society, cooperative society, thereby temporarily vacating the communication dated 4/7/2023. This court further has also serious doubts as regards the power so exercised by the in charge journal joint register of cooperative society, taking into account the power in taking into account section 49(2)(l) of the Act of 2007. On the very date, the board, a meeting of the board of directors of the cooperative society was called and held at 11 a.m. Serious allegations have been made that the said meeting was called without compliance to section 43(5) of 43(6) of the Act of 2023, 17 or 7, read with bylaw 7(6)(a) of the bylaws of the cooperative society, which mandates a 4 days notice to be issued. This court further has serious doubts on the authority of the respondent number 6 for calling of the meeting of the board of directors, taking into account the mandate of section 43(1) and 2 of the Act of 2007. Taking into account the above, this court therefore is of the opinion that as an appeal is already pending before the register of cooperative society, who has the authority to decide the said dispute, more so in view of section 49(2)(l), this court is not inclined to deal with the this court is not inclined to adjudicate the matter which is presently pending before the register of cooperative society. As the issues so raised in the instant petition have also been raised before the register of cooperative society. Be it as it may, this court also finds it relevant, taking into account the observations so made that the order dated, that resolution so adopted on 5/7/2023 is required to be stayed pending decision of the appeal prepared before the register of cooperative society till the disposal of the said appeal. This court had done so, taking into account the serious consequences would ensure if the said order is not stayed pending disposal of the appeal. Full stop. Accordingly, the board's resolution dated 5/7/2023, the board's resolution of the Cooperative Society dated 5/7/2023 is stayed till the final outcome of the appeal preferred before the Register of Cooperative Society. The Register of Cooperative Society further is directed to dispose of the said appeal at the earliest and preferably within 5 days. On that day now? No, you won't. Within 10 days. 10 days.
My lord,
You are going to give a certificate.
my lord, observation made in this, my lord. Observation made in this, my lord. Order, my lord, should not be considered any precedent.
Yeah, within 15 days from the date of the instant order. To date, a certified copy of the instant order is served by either of the parties before the Register of Cooperative Society. It is further observed that the respondent number 7 and 9, that is Sri Sudhanshu Das and Sri Jiten Das, shall also be heard by the Register of Cooperative Society prior to during the said appeal proceedings. Full stop. This court further finds it relevant to observe that the observations made herein above are for the purpose of deciding the entitlement of the petitioner to the interim for deciding as to whether the petitioner is entitled to the stay of the board's resolution dated 5/7/2023 pending disposal of the appeal. The above observations shall not influence the Register of Cooperative Society while deciding the appeal on merits. Take this. It may help you.
Court number 17.
I have gone through the affidavit filed by the government, my lord. So I think, my lord, it requires no affidavit. Because, my lord, because, my lord, other of the petitioner died in 1993, my lord, and
Your father died when?
father died on-
1993.
Oh, yeah, 2003, 11/6/2003. And affidavit says, my lord, he filed an application after 5 years. Perhaps, my lord, he does not have any right.
So what remains?
After But Taxman remains that, my lord, he initially approached this court, and there was a direction by this court, my lord, to make necessary recommendation if so, if he is otherwise entitled. Then his name was recommended to the SLC by the, my lord, district level committee. And later on, my lord, the district committee didn't do anything, and he approached this court, and they filed affidavit saying that, my lord, application was filed after 5 years.
You filed the application after 5 years.
Yes, according to them, my lord, I have also confirmed.
You filed after 5 years.
Yes, because, my lord, he very tactfully And I've been engaged in this case, of course, I have nothing to say. It actually says immediately after the death of my father, I made application, but he didn't mention any specific date.
The instant writ petition has been filed. Seeking a direction upon the respondent authorities to appoint the petitioner on compassionate ground to a post in the grade 4. It appears from the records that the petitioner, the father of the petitioner, who was working as a grade 4 employee in the office of the Panchayat and Rural Development Department, Golaghat, died in harness on 11/6/2003. The petitioner submitted his application for appointment on compassionate grounds on 15/9/2008. It's okay. An affidavit in opposition has been filed by the respondent number 1, wherein the office memorandum dated 2nd of March 2009 have been enclosed. In the said office memorandum, it has been mentioned that applications for appointment under the scheme in the prescribed format should be submitted within a period of 3 months from the date of the death of the person. On the ground that the petitioner had submitted the application after 5 years, the petitioner's application was rejected. This court finds it relevant at this stage to refer to a judgment of the Supreme Court in the case of State of West Bengal versus Debabrata Tiwari and others, reported in 2023 SCC Online SC 219, wherein at paragraph number 32, the Supreme Court, after making a copious detail of various judgments, observed the various principles which emerge for compassionate appointment. In paragraph number 35 of the said judgment, the Supreme Court further observed when applications for compassionate appointment could not be considered after a delay of several years, either on account of the fault of the applicant in claiming compassionate appointment, or on account of the fault of the authorities in deciding their said claim, the sense of immediacy is diluted and lost. It was further observed that the financial circumstances of the family of the deceased may have changed, for the better since the time of the death of the government employee. In such circumstances, courts or other relevant authorities are to be guided by the fact that for such prolonged period of delay, the family of the deceased was able to sustain themselves, most probably by availing gainful employment from some other sources. It was further observed that granting of compassionate appointment in such a case would be treating a claim for compassionate appointment as though it were a matter of inheritance based on a line of succession which is contrary to the Constitution. Paragraph 32 to 35 of the said judgment being relevant is quoted herein above. In the instant case, as would be seen, that the petitioner's father expired on 11/6/2023. 20 years have passed by when the instant matter is taken up for adjudication. This court is of the opinion that in the meantime, the family of the petitioner was able to, the petitioner as well as his family, of the opinion that the petitioner as well as his family for the last 20 years have been able to sustain themselves, most probably by availing gainful employment from some other source, inasmuch as there is no indication by filing any pleadings or documents that the family of the petitioner is still in a perilous state. Under such circumstances, this court is of the opinion that the directions are sought for grant of a compassion, for directing the respondent authorities to appoint the petitioner on compassionate as petitioner, directing the respondent to appoint the petitioner on compassionate grounds does not arise, for which the instant petition stands dismissed.
Item number 4.
Mr. Purkasa, some justice has to be done, so that is why this judgment have been mentioned.
This judgment will cover all related applications.
Chalo. Yes, who is here? Yes, tell me what is your case?
My lord, the petitioner is presently working as driver, Assam rifle fighter. He was appointed in the year 1999. The year 2010, my lord, one incident happened, my lord. He made a complaint.
Are you still working?
Yes, my lord.
Then what do you mean?
Yes. And my lord, I am safe one. From 2013, I am medically safe one.
Huh?
Medically safe one, my lord. I am
Medically?
safe one.
So you good?
Yes, my lord.
So nothing remains.
Yes.
So you filed the petition on apprehension.
Yes, my lord.
You filed a writ petition on apprehension that these people have done something, they are going to terminate you
Yes.
or do something to you. So they have not done.
Yes.
So nothing will survive.
Yes.
Yes, mister. You are there. Police. What police? This is the Union of India. Union of India is not represented. Okay. The case of the petitioner herein, the instant writ petition has been filed. Apprehending that the respondent authorities may discharge or terminate the petitioner on medical grounds. The learned counsel appearing on behalf of the petitioner upon instruction submits that on account of the interim order passed, the petitioner have not been disturbed and is presently working. And the apprehension. Yes, madam. Yeah, madam. In this matter, this person was alleging that he may be terminated, apprehension. Now, all this while he has been working, there's nothing has been done. So we close the writ petition. That is, nothing is the apprehension is not there. So you don't do anything unnecessary unless you find anything. Illegal. I have not been disturbed pursuant to the interim order passed by this court. Taking into account the above, now, the learned counsel for the petitioner has also drawn the attention to the additional affidavit filed on 21/7/2017, wherein it has been mentioned that the CRPF Hospital Guwahati have placed the petitioner at medical category S3 bracket P24 in the year 2011 and placed the petitioner as medical category S1, that is shape 1, in the year 2013. What do you mean by shape 1? It's good.
Yes.
Taking into account that in the year 2013, the petitioner has been medically placed as shape 1. Shape 1 means SHAPE 1, all caps. Huh? The petitioner submits that his apprehension that the respondent authorities would discharge or terminate the petitioner on the ground of medically unfit, being medically unfit, is no longer there. He, however, submits, the learned counsel further, however, submits that in the future, if any further steps are being taken, on the basis of which the petitioner had apprehended, petitioner had apprehension, the petitioner may be permitted to approach this court. Taking into account the above submissions and further taking into account that in the year 2013, the petitioner had been medically characterized as shape 1. till date. This court finds no reason for the petitioner to have an apprehension that he may be determined or terminated, that he may be discharged or terminated on the ground of medical unfitness. Accordingly, the instant writ petition therefore stands closed. It is, however, liberty is given to the petitioner to approach this court in future if the respondent authorities initiates any action if so advised in accordance with law.
Number 2.
Yes, Mr. Chaudhary.
I'm constrained from your lordship because of accompanying circumstances, ma'am.
Tell me.
Your lordship kindly see the present petitioners are having a building over the Patta land. On 21st, my lord, your lordship kindly have a look to that paragraph, my lord. I have given everything, my lord. Paragraph 9, my lord. Page 10. On 20th evening, they have made some mic announcement, then they carry out the eviction of the house land. On 21st, my lord, they have come and they have evicted the people from house land. While doing so, my lord, they have also touched the Patta land also. And by this time, my lord, the corners of the building had already been dismantled. We protested, we wanted to show our papers. They did not, my lord, listen to it. Again, they have gone again today also, they are supposed to come at the evening for the eviction, my lord. So I come here, lordship, this building was constructed with the due permission of the municipality. And there is no doubt and no part of it, my lord, it falls on the government house plan.
So the land belongs to you,
Yes, ma'am.
wherein you have made construction.
Construction. With due
Now,
permission,
these people, who is this? Circle officer.
revenue minus circle officer and the police.
They are trying to evict you
Yes,
by demolishing that.
they will demolish it. My only question, you see my paper.
Actually, inspector. Actually, inspector.
Okay, state. Don't do anything.
Not from the Patta land, Lord.
Yes, yes, yes.
That's totally effective.
It is our specific
Don't
statement.
take any action in respect to the Patta land.
Yes.
Here, only the petitioner is before your lordship, but in
Brother.
the interim, he is claiming protection for his brothers
Brother.
also.
So building, I have with authority, my brother's smile will come. We have stated.
The land, the Patta has been issued in whose favor?
Yes,
So for
in favor of all the brothers smile.
Not you.
Yes, including present petition.
What is your name?
Building model, we made a common building model, joint building model. So it cannot be demarcated. Your lordship is the permission also, my lord.
Your name is what?
Yes, my name is Monir Ali Bhuya. Monir Ali Bhuya.
Monir Ali Bhuya.
Yeah.
So this is the building you have constructed on
Yes.
27/3.
Yes, ma'am.
2000 year basement, floor, ground floor, so and so.
Permission is, my lord.
Commercial building.
Building permission page.
So we are concerned with only this building.
This building.
So don't do anything in respect to this building. Wherein the as regards this
Covered by
permission.
dark number, patta number.
This is in mentioned in dark number to the way that the building permission.
Yeah.
And the original one.
Original sale date. Or building permission page 63, ma'am.
Is this the original one?
Page
Okay, yeah.
63.
So here the periodic patta dark number 205 and 206.
Yes, ma'am.
A period patta number 105,
105, 130.
A bazaar vita number. What is vita number? X.
Vita, mother, Vita.
Huh?
Vita to here.
Vita number X.
Yeah.
Near Doboka now Nagaon Road, G+2 floor, residential of the commercial purpose is hereby said.
In interim clear also I have given the my lord this description was given, description, page 16,
Page
page
16.
16.
Issue notice making it how much time?
Will allow him to take instruction, lordship, notice not to be issued on the next returnable date.
Hmm?
Lordship will issue notice on the returnable date because here the final prayer and the interim prayer is the same, lord.
Understood, but whatever may be, how much time you require?
1 week, lord. 1 week for instruction, lord.
Instructions, you can get it. Issue notice making it returnable on 7th of August. Possible?
7th of August. 7th of August.
That is what I
Seven,
said.
7th.
7th of August.
Oh.
Issue notice making it returnable on 7th of August 2023. Mr. N. Goswami appears on behalf of
2,
the
3,
respondent numbers 2,
3
3,
and 6.
and 6. Mr. P. Nayak appears for respondent number 5.
Not.
Ms. P.R. Mohanto appears, Mrs. P.R. Mohanto appears on behalf of the respondent number 1. How? What to do with the worker? How can we issue this thing only 1 week? Tell me.
Then 2 weeks, lord.
Issue notice making it returnable on 16th of August 2023. You take steps by the stay upon the book. Huh? Yes, you take steps upon.
Page 16 is the my.
As the respondent numbers 1, 2, 3, 5, and 6 are duly represented, extra copies of the writ petition be served upon them by 26th of July 2023. In respect to the respondent number 4, steps be taken by way of registered as well as usual. The petitioner is further directed to take steps upon the respondent number 4 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner, along with his brothers, are owners of various plots of land. Are owners of a plot of land measuring, what is the measurement?
22.66 lesser mile.
22.66
lesser.
Where are you finding it?
It is your lordship will find.
In a sale deed?
No, my our statement, my lord.
Huh?
Huh?
Bikri Dolil, this is there, na?
Yes.
Para 8, page 9, lord.
Bikri Dolil, how much is the land? You have purchased this by
Yes.
sale deed, na?
Yes, ma'am.
Bikri Matir, Uttore Iman, E Sohotor, Torot Matir, Iman. Number Iman. 18.66. 18.66. 18.66.
Two sale date, my lord. Two sale.
Which are the other sale deeds?
Yes. Second one is page 4. Page 18.
Huh?
Page 18. So first one is page 18. The second one is.
Yeah. The petitioner claims that the petitioner or this 3 by 3 port lecture.
Yeah. Yes, ma'am.
Yeah. Who is Haji Ayub Ali, your father?
My father.
The petitioners claim that the petitioner are owners of a plot of land, owners of plots of owners of a plot of land measuring
22.66.
66 lectures.
That means 1 kata 2 lesser.
22.66 lesser. Upon this, on the said land, the said land is covered by DAG number 205 and 206 and included in periodic patta number 105, 132 of Bazar Vita number X near Doboka Nagaon Road, under Jomunamukh Moza, Jomunamukh Moza, Doboka Revenue Circle, Town Kisam, full stop. On the said land, the petitioner, after taking due permission from the Doboka Municipal Board, had constructed a how much?
G+2.
G+2
Basically.
building for commercial purpose. It is the case of the petitioners that the respondent authorities, more particularly the respondent number 2, 3, and 6, while trying to evict persons from government lands, had damaged the corner of the building of the petitioner and his brothers, in spite of several protests, and would further take steps and several protests. Full stop. It is the final case of the petitioners that the said respondents, in the name of eviction from government lands, would demolish the petitioner's building, and as such, the petitioner has approached this court under Article 2 to 6 of the Constitution. Upon perusal of the materials on record and taking into account the deeds of sale, as well as the permission so given by the Doboka Municipal Board dated 23/7/2020, this court is prima facie of the view that this court is of the view that till the next date, the petitioners building standing over the plot of land covered by DAG number 205 and 206, included in periodic patta number 105/132, Bazar Vita number X under Moja Jomunamukh, within Doboka Revenue Towns Kisam, is required to be protected. Under such circumstances, this court therefore directs the respondent authorities, more particularly the respondent numbers 1, 2, 1, 2, no, 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 1 is not going to do anything. 2, 3, and 6, not to interfere with the possession of the petitioner in respect to the land covered by dark number so and so hekita koidlu na under Jamuna Muda so and so, as well as also the building standing thereon. List according.
For the 1 day, some communication may be available.
Huh?
So there is a clear chance of not right now, my lord.
Communicate.
Only was he may be informed, your lordship may record in the order, otherwise again it will fall.
Mr. N. Gustami, the learned counsel appearing on behalf of the circle officer, deputy commissioner,
And OC.
appearing on behalf of the respondent number 2, 3, and 6, shall telephonically instruct the said respondents about the order so passed today.
Obliged.
Item number 5.
Yes.
Yes, please, my lord. My lord, matter relates to removal from the service, my lord. My lord, petitioner was appointed as a woman constable, my lord, on 4/7/1998, my lord. And my lord, subsequently, she completed her training and was working as duty, my lord.
What is your present health condition?
Present, I am okay, my lord.
How do you say? When did you meet your person?
My lord, doctor was certificate, my lord. on
Where?
2010, my.
Huh?
2010, my.
We are not concerned with 2010 now. What have you done? And in the appeal, Mr. In the appeal, they have not taken note of that. Appeal have gone into the question. Here the petitioner has stated out here that look here, I was suffering from mental illness. Why the appellate authority did not look into it at all? The said respect. We should have inquired as to whether he has a mental illness or not. If he doesn't have a mental illness, to take a call. And during that period, whether she had a mental illness or not, whether she was incapacitated. Why haven't you done that?
Look, it was for at time of departmental process.
Understood. She could not. She said that she could not because she was suffering from mental illness. That is one aspect. She had filed an appeal, taking that ground. Your appeal decision does not say anything on that. Huh?
Dismissal order was passed on 2005 and appeal was passed 2011.
Understood. She was under this thing. Nah? She didn't know about it. He said that she was suffering from mental illness. You have to take a decision on a call on that. Does your appellate order say a single word on that? Does it? You are reading the appellate order now. We remand it to the appellate authority. Take a call.
Yes.
That is the only way. Because you have not decided anything on that. How can this court now decide? You are the final authority on fact, the appellate authority. Take a call. You have to take a call as to whether at that point of time these documents were enough to look into it. Whether she was suffering from mental illness, whether she has recovered. If she has recovered, you should have. How can this court today do anything to the effect? Or give them something? Now if she's fine, appoint her somewhere. He was 32. When did you file the writ petition? What was the age?
42 my God.
Huh?
Presently maybe 43.
Now she will be 52.
42.
फिर क्या वस्तु?
42.
At the time of filing,
No. At the final, we are just 30.
so she will be now 42. So take a call. Whether she can be brought out there or not. That is the only way out. Because you see in the appeal order, you have a look at the appeal order and then I'll hear again. Let him look through it. Yes, next.
Item number 23, part heart.
Sorry, Mr. Burago, I'm keeping you waiting for such long.
Lordship, I have one prayer in this matter, Lordship. Mr. S.P. Kealu is appearing for respondent. Today his leg was injured due to some accident in morning time, Your Lordship. So my prayer is this matter will be taken up on day after tomorrow, Your Lordship.
Take it up there. Have you got any judgments on that?
My lord, we have found some judgment.
And Mr. Buranga, also look into another aspect. I'm just giving it to you.
Yes.
Yesterday I was looking into it. Otherwise, we actually don't get time for other matters to look into it much. But have a look at this 11HC. 11 capital H C. Small c, huh?
Yes.
What is the specified area? Specified area has been mentioned as 100 kilometers from the border. We don't come under this 100 kilometers with it.
Read everything.
Huh?
Read everything into mind.
Just find out.
I
will look at it. We'll look at it.
I got some judgments.
It's okay. You give it on that day. Tomorrow. Day after, I'll pass the order. This is the matter on 27, 2023 for further hearing. She should have said in the morning. You may not have been waiting.
Later to hear to proceed.
Huh?
I have to mention some matters in code number 1, Your Lordship. Sorry.
Well, it was my pleasure. I was there. I learned from the case.
Item number 6 to 19.
Mr. Goswami, you read that file. Read the appellate order. I'm coming back. What are these judgments? You have given written submission on behalf of the respondent court. What is this judgment? What is this written submission of?
It was submitted before the court number 1, 2.
Okay.
We have in this case,
Now you have realized you have no power.
okay.
That you have realized. So you don't take any action. So we are going to interfere with that. That you have no power. And you have stopped from
12/6/2020.
12/6/2020. It will help. 12/6/2020.
There is a notification in there. I have annexed in the written submission.
Where is it? Oh, this one. Oh, it could be option.
By the chief executive officer.
Take. Take a question. Itu agas tu kiba pro tu. Sorry. Itu agas. It pani trino to inuko. So from here you have stopped.
Stop. Today stop the collection.
When were the repetitions filed?
Petition filed in the year 2020, Lordship. But it was filed in 2019, Lordship. So
Huh?
this-
Some are filed in 2018, some are in 2019.
in 17 also there was.
17 also, but there are some petition filed in 2007.
17. So you have challenged but after the GST is coming, 1/7/2017.
Only after,
17 and 17.
not even a single.
So at that point of time, you could not. And from 2010, you have not.
2020, Lordship.
2020, you have not. So only for this period from 2017 to 2020, so much you have collected. Do you have a record?
Report is at that time.
No. How much you have collected?
That is also not with me, Lordship. I have to collect the instruction.
Then only you can give it to somebody else.
Basically, then I want to obtain instruction what the amount which has been collected from the after GST. Because it was collected in various market committees. The petitioner is from the Sipsagar Market Committee and from where in Duhat.
Yes, petitioner, how much have they collected from you?
Lordship, at page 135, the order, there is an order of the Honorable Court in 2017 itself. As soon as we challenge the thing, Lordship, this Honorable Court gave the order asking them to keep a proper account of the sex collected from the petitioner, so that in the event the petitioner succeed in the petition, the board can immediately refund the amount of sex collected. This is the order which is page 135 of the text.
That order is dated?
Page 135, Lordship, this order is dated 13/3/2017.
Passed in?
Lordship, WPC number 1101 of 2017. 1101 of 2017.
Very good.
In the order dated, Ms. N. Havalia, the learned counsel appearing on behalf of the petitioner, has drawn the attention of this court to the order dated
3/3/2017,
3/3/2017, passed in WPC number
1101 of 2007.
1101 of the
2007.
2017,
Yes, sir.
wherein there is an order. Where is that order? You have enclosed, na?
I have enclosed in the Lordship this
Page.
book, page 135. Last paragraph.
Wherein there was a direction being given to the
Marketing board.
Assam State Agricultural Marketing Board to keep proper account of the cess collected from the petitioner company, so that in the event the petitioner succeeds in the writ petition, the board can immediately refund the amount of cess collected to the petitioner. Similar orders were passed in others. It further appears that in similar orders were passed in the other writ petitions also.
Not others, sir.
Not all, but Lordship, it was for
It
directly
was
for
only
all the-
particular this case, Lordship.
Eh?
This is only particular this case. Lordship.
Not
This
all the
this
cases.
is pending.
Lordship, but it was for all the petitioners. Lordship, may kindly see that the order is said, petition company is that all the petitioners succeeding. Thereafter, they.
Because there are two petitioners here.
Yes.
Only this case, Lordship.
Uh,
Not for all the cases. Sir.
Lordship, there is only one petitioner over here.
It is the medical.
No, no,
medical
there are two
limited.
petitioners.
One.
This is the medical limited. Lordship.
And others, there is no order.
No specific order. Specific.
This court asks Mr. N.J. Gogoi, appearing on behalf of the Assam State Agricultural Marketing Board, as to whether any proper accounts have been maintained in respect to the petitioners in the instant batch of repetition. And as to how much amount of cess has been collected from the petitioner in the meantime, pursuant to the filing of the repetition. The learned counsel submits that he will take instructions in the matter, taking into account the above. Is the matter again on 8th of August 2023. 8.
Can it be after 16 also? Because
Why?
we have to collect from the Juhat, Sipsagar and other districts also. So it will take time also.
Okay, we'll have it on 17th of August 2020.
Can it be on 22?
Well,
22, but that's also one or 2 days.
22.
So
August.
Good of. Then only we can award how much goes to whom.
but other state already collected states after GST.
Huh?
Other state like Rajasthan and other states collected states after the GST. I have the notification is there.
Let them do it. You don't do. Others said, how can they do it when the GST has already given an exemption, meaning thereby it falls within the exemption? Somebody has not a sale, does it mean that everything has happened?
And if it go to charity, they should not object also. It's going to charity only. They should not object. The entire amount is almost is
Right
going-
now we are unable to pay the salaries of our employees from last 9 months.
Whatever may be. That is your lookout. Why have you should have known once it had been subsumed on the basis of an order passed by the authorities? You couldn't have.
But there is an order from the brand payment that only
There is an order from the
brand payment that which I have annexed in my affidavit of
order by.
Agriculture Department. Agriculture Department.
Oh,
For collection of sales lordship. I have
now does the agricultural department has the power to collect cess?
no they empower us to collect sales in the
Or what?
after GST.
How? What is the authority? You need an authority, no?
So lordship, but
Where is your authority? Once it has been subsumed, how can you do that?
they have not challenged it lordship. 31st July 2017. Wherein it was stated that
They have challenged that you cannot do anything after the GST coming. That's enough. We don't require other people out. You cannot take any money after or collect cess after the GST coming. Tomorrow the state government may say that we want to collect entry tax. They may. But is it permissible under law? No. You can't. It has been subsumed. You go meet the GST council, say that we are not able to run our affairs, pay us some money. Ask your government out here to pay you. In fact, now the government gets the compensation. Every quarterly, the compensation is given by the GST council to the government. From there, you have to run. How are you running now?
now employees have not received any salary from the
Understood, but how are you running? I think on the basis of grant
lordship.
of the government. The
Grant from
government has to give you the grant.
But last 9 months we have not
As per your act, you have an act.
lordship.
As per your act, how do you get your resources? How do you manage if
Earlier
you
we
don't
managed-
collect cess?
as per section 20, we earlier collect cess and then we utilize some amount to the employees for the salaries and other.
The council, one aspect is there that you are collecting, from there you are paying. That is one aspect. The other thing is, how are you running otherwise? Are you getting grant in aid from the government?
Yes, sir.
Under what provision?
Now after the closing of the GST, not loss, from the 2020, government only give us the grant lordship. Earlier they have not done it. Financial aid.
Earlier it was not required. You were unnecessarily collecting from everybody.
Not unnecessary lordship. We are collecting after as per the act lordship, section
But that has been set
21.
aside by the Supreme Court.
Not a circular head.
What?
It was not circular head.
By this court, it has been set aside. You can't collect it. That's what happened to the Supreme Court. The Supreme Court, when the matter went out there, it was said that the matter was the High Court had decided a repetition on the basis of the pre-existing provisions without taking into account the amended. Isn't
Okay. In after the division was stated that there is no virus in the 2012 and 2008 judgment. After that, some of the petitioners filed and condemned petition against the chairman and other CEO and other officers. We also approached before the Supreme Court. Supreme Court in the interim order directed us to collect shares in the contempt proceeding. In last lordship, I have annexed the order lordship in my written submission.
Mr. Counsel, let me tell you, with due respect to the division bench, when the division bench passed the judgment was passed in Assam roller flow. So Assam roller flow means petitioner became very happy. They partied that. They went there. Filed a caveat in the Supreme Court. 2 days later, they realized that the case went against them. Then Assam Agricultural Board said that we are more happy. And as such, the Assam Agricultural Board also filed a case. So it was not clear who had. Then the submission which was made at the time when the SLP was moved was, how could the High Court have passed the order without taking into account the provisions of the Act have been amended? And it is on that ground the stay was granted. Yes. I know that. Not necessary. Just find out how much you have. Proper account.
In fact, a clarification was also filed that nobody was sure that in whose favor the order was passed.
Yes,
That was a,
that was the difficult.
it became a very famous judgment. Much of that.
Highly obliged.
Yes, Mr. Gustave. Is there anything?
Okay. But from the inquiry report, it is found
Forget about the inquiry.
because she has received the notices by herself.
Whatever may be. Why didn't you take note of in the epic? Have you written a single word that she was not mentally ill? We have looked into the documents. Anything?
Okay, but
That was the ground of appeal. The ground of appeal was that, look here, during this period, I was incapacitated on the basis of mental illness. Why I'm saying it? Otherwise, I would have dismissed this petition on the face of it. You see, when a person is in mental illness, you are protected by various provisions. You can't take up this decision unless you take care of it. Say that, yes, he was not, the documents are not, you have sent it to the board comes to a finding that no, nothing to do. How can this court decide this aspect? On the face of it, it amounts to a violation. You have not taken, so why shouldn't I interfere with the appeal? Once I interfere, the appeal has to be remanded back. Decide, take a call.
Which had been phrased,
Absolutely.
in the appeal law.
Yes. Because that is his grounds which have been taken. Because you have to also take note of, because now she has to also submit. Because you see, that is why I asked him as to what is the present state of health of the patient. Because in 2010, she said that it was okay. We are in 2023. What happened? Is she still fine or not? So let the, I think the appellate authority decide that.
She will file a fresh appeal.
Huh? That appeal is already there. You decide. Why should she file it? On one hand, you have not paid. She is out of service. She will have to get hold of another lawyer. You want to drop the appeal for her? Then? The petitioner herein being aggrieved by the order of removal dated 5/11/2005 And the non-consideration, 5/11/2005, and not for treating the period of her absence as on duty, has approached this court by filing the present writ petition. The case of the petitioner herein is that the petitioner was appointed as a woman police constable on 4/7/1998 at Morigaon Police Reserve. After completion of training, the petitioner was posted at Moirabari Police Station, where she resumed duties on 6/10/2001. It is the case of the petitioner that the petitioner continued to render her service without any blemish till 27/10/2004. However, unfortunately, the petitioner suffered from mental illness and became senseless, for which the petitioner was compelled to take necessary medical treatment. It has been stated out here in the writ petition that the petitioner had taken had taken treatment in the neuropsychic clinic Nagaon, as well as at the Lokpriya Gopinath Bordloi Regional Institute of Mental Hospital, Tejpur. During this period, when the treatment was going on, the petitioner received show cause notices. But on account of her mental ailments, she was not in a condition to reply. The petitioner claims that she recovered from her mental illness in the month of July 2007. 2010. And the medical authority had also given a certificate in that regard, to the effect that she is cured and would be able to join her previous job. Thereupon, the petitioner approached the respondent authorities that she may be permitted to join, whereupon the petitioner came to learn that on the basis of a departmental proceedings number 1/2005 drawn against her, during the period when the petitioner was suffering from mental illness, she was removed from service with effect from 5/11/2005. It further appears that the petitioner thereupon prepared an appeal on 23/9/2011 before the respondent number 4, that is the Deputy Inspector General of Police CR Dipu Karbi Anglong. In the same appeal, she had duly mentioned that she was incapacitated during that period on account of her medical illness. The said appeal, however, was dismissed by an order dated 27/2011. How can it be? Where is the appeal? How can it be dismissed on 27? Mr. Counsel, how is it possible? If your appeal is dated 23rd of September 2011, how can it be dismissed on 22/7/2011? How is it possible?
My lord, in the affidavit in opposition is written at 35/2011.
Huh?
35. My lord, whatever, my lord, the earlier there is the petition, my lord. That petition is considered as an appeal, my lord. On that petition, my lord, this order was appeal order was.
Which one?
My lord, it is on page,
Which petition?
my lord. It is on page 48.
Huh?
Page 48.
Now, what happened to this appeal? That has not been decided. This was decided as appeal.
This
So this appeal is pending.
as per that-
You have not taken any decision on this.
Let's even though, my lord, in this petition also see annex all her medical documents, my. Even that petition, along with that petition also, my lord, the annex are all medical documents. Page 49, my last part, my lord.
Page paragraph 13, what is the reply? Okay. लिख ले लाइन तो लगता होता है ना ता अकोमन आकोते ता लाइन तो लिख हाँ after recovery করার পিছতে 37/2010 এর ভিতরে এইটো 10/7/2010 ত যে রিকভার কইলে লিখিল ন 10/7/2000 an opinion was given, medical certificate was given pale. Then the petitioner sought to pale 10/7/2000. Thereupon the petitioner submitted an application before the Director General of Police, Assam, on 30/5/2011, along with relevant medical reports stating inter alia to allow her to join in service as she is now. No, absolutely. Thereupon, the petitioner approached the concerned respondent authorities, thereby permitting the petitioner to join. When she came to learn that by an order dated 5/11/2005 in Departmental Proceedings number 1/2005, the petitioner was dismissed from her service. The petitioner thereupon submitted an application on 30/5/2011 before the Director General of Police Assam along with relevant medical documents. Full Subsequent thereto, the petitioner had again submitted another communication dated the said communication dated 30/5/2011 was forwarded by the Deputy Inspector General of Police A, Assam, to the Deputy Inspector General of Police (CR), Difu, Assam, to look into the matter thoroughly and take necessary action by the communication dated 5/7/2011. The petitioner further, by another communication, had further filed an appeal on 23rd of September 2011 challenging the order of removal dated 5/11/2005 before the Deputy Inspector General of Police CR, Difu. The said appeal, in the said appeal, the petitioner have duly and in detail stated about her medical illness and have also enclosed and had also enclosed the relevant medical documents in that regard. However, as no action was taken on the said appeal, filed on 23rd of September 2011, the petitioner filed the instant writ petition on 14th of December 2011. This court, by an order dated 21/12/2011, issued rule it appears on record that the respondent number 5 had filed an affidavit in opposition. In the said affidavit in opposition, various details have been mentioned as to how the departmental proceedings was initiated. And how the notice was duly served. And the order and the order of dismissal dated 5/11/2005 was justified. In paragraph number 11 of the said affidavit in opposition, it was mentioned that the application filed by the petitioner on 30/5/2011 was forwarded to the Appellate Authority, who passed an order on 22/7/2011, thereby rejecting the appeal. There is, however, no mention whatsoever as regards the fate of the appeal so filed on 23/9/2011. This court further finds it relevant to take note of that Annexure 3 is the order dated 22/27/2011, 22/7/2011, passed by the Deputy Inspector General of Police CR, who is the appellate authority. A perusal of the said order, in the opinion, a perusal of the said order, however, do not in any manner disclose that the said appellate authority had taken into account the petitioner's mental illness during that period. And have merely decided the appeal on the basis of the formalities on the basis that the order dated 5/11/2005 was passed by observing all the required formalities. Next. This court have heard the learned counsels for the parties. The basic issue the basic issue on which the petitioner have assailed the order dated 5/11/2005 is that the said departmental proceedings was initiated at a time when the petitioner was suffering from mental ailment, which incapacitated the petitioner from contesting the said departmental proceedings. This very aspect was duly taken in the communication dated 30/5/2011, as well as also in the appeal which was filed on 23/9/2011. This court have also perused the order dated 22/7/2011 passed by the appellate authority. However, strangely, the appellate authority did not take note of the said aspect of the matter as to whether the petitioner was actually incapacitated on account of medical ailment, on account of mental ailment, to contest the departmental proceedings. Or the mental ailments was as such which were which could have been condoned for the purpose of allowing the petitioner or the mental ailment was as such for which the petitioner was justified in not performing her duty during that period. The medical documents which were placed by the petitioner, the reference of which could be seen from the letter dated 30/5/2011, as well as the appeal which was filed on 23/9/2011, have not at all been taken into consideration or discussed by the appellate authority. Taking into account the above, this court is of the opinion that the appellate authority have not exercised its appellate powers in the manner in which it ought to have done so. The fact that as to whether the petitioner was incapacitated or as to whether the petitioner can be allowed to rejoin are questions which needs to be decided on the basis of material, on the basis of certain fact finding to be carried out by the appellate authority. Fact finding to be carried out by an authority empowered to adjudicate such facts. This court under 226 of the Constitution is would not like to venture on this aspect of the matter. As the same would require adjudication on certain questions of facts. It is under such circumstances this court therefore sets aside the order dated 22/7/2011 passed by the appellate authority, that is the order by the Deputy Inspector General of Police CR Assam, and directs the said appellate authority to decide afresh the appeal so filed by the petitioner on 23/9/2011 by giving the petitioner an opportunity of hearing. Accordingly, the court therefore disposes of this instant writ petition. Thereby directing the appellate authority, that is the Deputy Inspector General of Police CR, to decide afresh the appeal so filed by the petition. The petitioner is further directed in this regard to serve a certified copy of the order to the Deputy Inspector General of Police (CR) Assam Dipu, along with a copy of the memo of appeal, along with a copy of the memo of appeal, thereby enclosing therein the necessary documents on the basis of which the petitioner claims that she was incapacitated on account of mental ailment during that period. The said appeal be decided within a period of 3 months from the date a certified copy along with the documents as stated herein above is served upon the respondent number 4, that is the appellate. Right. Yep. Yes. Anybody hearing?
At number 20.
(2017) matter. Oh, what remains in this case? Oh, Forest Department?
Forest.
They just say something needs to be done. The forest is not bordered. It's the case of settlement. Who are you?
I'm for Cooperative.
You are the person who got it.
No, there's nothing was finalized. Nothing was finalized.
So you are nobody.
Right now, my lord, I don't have any instruction.
Huh?
Because after
They just stay. What happened? Where is Mr. Digo? I saw him come now. We are still having time. There's a stay. How can a stay operate for such a long time? And settlement was made for how much? What was the period of settlement? It will go for fresh one then if it is so.
I think I don't know. Clarify whether this still.
I think this government must have thought about it. This was done long time back in 2014. What are they challenging? The short notice.
They were challenged.
Zone
for remand.
The sector will be open. This case,
Fresh tender was challenged.
what is it? Go for a fresh one. Get hold of that person concerned. You are respondent number 3.
I'm 4. I'm the private respondent. My affidavit otherwise not required. In that order dated 3/4/2017, it will be as an interim measure, provided the respondent may process the tender but shall not issue any final order or settlement.
Understood. But what happened thereafter?
After the updated instruction.
You have not filed any application for
I have-
vacating.
But we had, in fact, we had impleted ourselves after being vacating an order. Okay. 20.
Yes.
Madam, my passport timing, my letter is there, madam. Will come.
Okay. Ask him to come.
That's a lot. Hello.
What remains?
Passport timing, my letter. He's there, madam. I'll call him.
Huh?
I'll call him. I may be allowed to call him, madam.
Call him. You take
Hello.
up. Next.
21.
Yes, 2022 matter. What is there?
Earlier this morning, I prayed for adjournment. That's my senior is out of station.
Huh?
Earlier this morning, I prayed for adjournment.
This one? You asked for adjournment. Why?
My senior is out of station.
You're obtaining an injunction or stay.
There was an interim order.
Interim order.
Matter will be taken by next Tuesday.
Interim order for what?
Don't have the complete page.
Petitioner so and so was seized by the forest officer. Against the order dated passed by the divisional forest officer prepared an appeal under the being appeal and until further orders what will remain? What will happen to your if you delay it? Hello. The Learned Council appearing on behalf of the petitioner seeks for an accommodation. This is the matter again on 21st of 22nd of no. This is the matter again on. This means it goes after 3 months. That will be listed again on 6th, 7th of November 2023. Interim order passed earlier shall continue till.
Okay.
22.
Yes.
Is the lordship. My lord, here in this case, my lord, the petitioners are
staying on a government fast land.
Oh,
But the railway authority, my lord, is trying to evict them. They have visited the site and threatened them to leave this place, my lord, without issuing any notice. My lord, therefore, my lord, they approach,
who is trying to evict you?
my lord, the railway authority. They are claiming that the land is the railway land. But
Fantastic, but how? How? The railway won't go there and throw you out.
my lord,
Railway will do so under the public premises.
yes, my lord.
Have they done that?
They have not done it.
So let
But-
them do it. The railways will do it only under the public premises.
Yes,
Like
my lord.
once they do it, the law will take its own course. But what remains?
But they are
We can only dispose it of saying that the railway shall do so in accordance with law, following the due process of the law. Under the Public Premises Act, they will do it.
they have to issue notice, but
They will do it.
they have not done it. But they have visited the site and threatened the people, my lord, to leave.
Huh? Annexus 7. 7. Yeah, this is what is done. This is the notice. They have initiated. Why should this court
This notice
initiate?
is not to me, my lord, to other people, my
Oh.
lord. And they have approached this honorable court after receiving the notice.
Then what happened?
My lord, there is a stay and the case is still pending.
How can this court stay? You have any problem? Go
My
there.
lord, notice was not to us. Notice was given to other people.
So they will issue notice to you. You will be at liberty. As no notice has been issued. You see, this shows the bona fide of the respondents, the railways. The railways categorically say that they are going to do it as per the Public Premises Eviction Act. They will do so. Okay. You have this, then file an appeal. District judge is there.
Yes, my lord.
Well,
And
let
if
them
they-
first do this. First do this. Then you will have a reply. Then you have a district judge. District judge passes an order, you have the 227. After 227, you have 136. So, we happy. What is there?
My
I
lord,
can dispose it of the petitioner, that knows the petitioner are in occupation of certain lands. The respondent railways claims these lands to be railway land. It's made clear that if the railways wants to take any action on that land, they shall do so under the appropriate provisions of the law.
and my claim is that this is not a railway land. It is a
Well,
government khas land.
Mr. Counsel, if it is a government council, then go and show it. Show it before the railway authorities. Then look here, this is a government cast land. You know
Yes, my lord.
what is to be done. 41 petitioners have joined together to file the present writ petition. Challenging the actions of the respondent authorities in trying to evict the petitioner from the said land. Challenging the respondent authorities, more particularly the railway, the NF railway, and more particularly the respondent number 3 and 4 to evict the petitioners from the said land. It is the case of the petitioners that the lands upon which the petitioners are possessing, on which the petitioners are possessing, are government trust lands and not railway land, not lands of NF railway. And as such, the state railway authorities had no authority to disturb the possession of the petitioners. From a perusal of the writ petition and more particularly Annexus 7, it reveals that the railways are initiating proceedings under the provisions of the Public Premises bracket Eviction of Unauthorized Occupants bracket close Act 1971. It is the opinion of this court that if any notices is the learned counsel for appearing on behalf of the petitioner submit that the petitioners till date have not been issued any notice. It is the opinion of this court that the law permits the railway authorities to initiate proceedings under the Public Premises Eviction of Unauthorized Occupants Act 1971 in respect to the lands belonging to the railways. It is the further opinion of this court that if such proceedings or notices are issued under the said act upon the petitioner, and the petitioner claims that the lands belong to the government, are government cast land and not railway land, the petitioner would definitely have an opportunity before the estate officer to show the same by filing the reply. Under such circumstances, this court is of the opinion that the exercise of jurisdiction under Article 2 to 6 in the instant proceeding cannot be done so. It is, however, observed that if the railway authorities take any action against the petitioner, the same has to be done in accordance with the provisions of law. And the petitioners herein would be duly given the opportunity as mandated under the Public Premises Eviction of Unauthorized Occupants Act 1971. With the above, the instant petition stands. You see, they are challenging out there that they are going to evict you. You are trying to evict them. I am saying that you can only evict them only under the Public Premises Act. You can initiate a proceeding. They have a right to reply under Section 4. They will reply, you decide, take an action. But how? I can't keep this writ petition pending out here.
Otherwise also it is railway land. There is a certificate.
Understood. Whether it is not, let them show. You throw them out. Section 5, whatever may be. Interim order passed earlier stands taken.
My name is My name is
Give your slip. Yes, Mr. Day, your matter. 20. What remains in this case? What remains in this case? They will let them go for a fresh tender or whatever. You are concerned with the tender.
My lord.
So let them go for a fresh tender. Unless they are keeping the matter pending out here. Where is Mr. D. Gogoi?
I'm not able to locate him or his junior. I saw the junior while before.
Get hold of a forest council. Is it available? No. Okay. Tomorrow at 2 o'clock. We'll take it up. We'll finish it off. This is 2017 stays there unnecessarily. This, if you are agree with the settlement or any thing that has not been finalized, let them go for a fresh settlement for that.
They're about to be settled with us. The submission of date of tender is already expired.
So nothing remains. So let them go for a fresh tender. What right do you have if it is not been settled with you? You don't have a right. He also has no right. And what is happening? Both of you don't have the right. The people are losing.
Without reason, how could it be? How earlier tender NIT could be given a go by and
Oh, that is the round. There's no problem. There are many Supreme Court judgments. That earlier NIT can be given a go back. That is absolutely their decision to do so. So it is clear the government can very well do so. But anyways, they will go for a fresh tender. Let them go for. You have no right. There are many judgments on this point. We'll take it up at 2 tomorrow. Ask Mr. T. Gogoi to be there. Please the matter tomorrow at 2 p.m.